Hello? Can you all hear me? Can we get I'm sorry, hey.
Yes.
Can we get a breakout? Can we get a breakout session with the Portuguese interpreter and whoever the attorney is, please?
That would be me, PD Holly.
Thank you. Come on, man. Get your interview, okay?
Good afternoon, everyone.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Hello, everyone. All right, you ready to get started?
Yes, Your Honor.
Okay. All right, we shall do that.
Your Honor, while we're waiting, I just wanted to inquire on
Almondo Bussey. He has been on our calendar for a little over a week now, and there has not been a waiver filed or any indication that he is coming out of medical court.
Miss Falk.
He's coming out today.
I have him right here. He's right here.
Thank you.
Okay, so we're gonna get it rolling, right, Judge Mincy? We got a lot today.
We're ready to rock and
Yeah,
roll.
we have a whole lot today.
Let's move fast. Let's go, Judge. Let's go.
All right, the pressure's on. I'm gonna try to talk fast. Here we go. All right, ladies and gentlemen, I am Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge. So we're going to, and are able to rather, address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. Going to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. And also remind the defendants that you do have a right to remain silent. Anything that you state about the facts, the circumstances, or the occurrences of your case can and will be used against you. Listen to your attorneys, which you do have a right to an attorney, and govern yourselves accordingly. All right, Miss Bridgewater, what's that reset date?
December 27th.
27th, okay, December 27th is our SAP reset date. All right, who do you have first? I just saw an add-on.
So, good afternoon, Your Honor. The South Annex, position number 1 is before you, Miss Blake.
All right. This is 22 CR 008220F. That's Shandy Blake. You're charged with 1 count of simple battery, family violence, and a 2nd count of simple battery. The offense date is December the 10th, 2022. Pre-trial.
This is our first arrest.
First arrest, okay.
Yes.
Thank you.
Ms. Falk, Your Honor, here for the state.
Yes.
This incident happened December 10th, 2022 at 1026 Valley View Road Southeast at around 4:30 p.m. Elijah, and that is ELIADJH, Duggar, DUGGER, stated that she was assaulted by her roommate, the defendant, in front of her daughter, initials PD, who is age 3. The defendant became aggressive during a verbal dispute. Ms. Duggar then began recording on her cell phone. At that point, the defendant slapped the cell phone out of Ms. Duggar's hand and began hitting her. The officer was able to review the footage, which showed the defendant walking up close to Ms. Duggar while Ms. Duggar is pleading for her to stop. And on surveillance camera, the officer observed the defendant walk away from Ms. Duggar and then walk back and use her right hand to slap Ms. Duggar. The officer could also hear in the video Ms. Duggar yelling for the defendant to get off of her. The officer then spoke to the 3-year-old PD, who stated that the defendant was hitting her mother and she told her to stop. The defendant was not present at the time, but returned back to the house later that day and was arrested by the officer. Although the defendant doesn't have any priors, we do have some concern regarding this incident. The fact that the 2 of them were living in the same residence at the time, and the fact that this escalated as quickly as it did. The state is recommending a $2,000 signature bond on count 2 with a $2,000 surety bond on count 1 for a total of a $4,000 split bond. Stay away from the incident location. No further contact with Ms. Duggar, and PD, the minor child, and no alcohol, drugs, or weapons. We are also requesting 1-day anger awareness. The state did NOD the cruelty, and we did send that to the jail as well as to the clerk's office. That is all for the state.
All right, thank you. And on the PD side, who do we have? I see a couple of names.
I was in the breakout session. Can I have the name of this defendant?
This is
Shandy Blake.
Shandy Blake.
That's mine.
Okay. All right. Thank you, Ms. Holly.
Good afternoon, Judge Mincy.
Good afternoon.
I spoke with Miss Blake, and she is 38 years old. She lives in Southeast Atlanta in Jonesboro. She does have no criminal history, and she is nearly 40, so she has gone her entire life with no issues. She does work as a caregiver for an older gentleman as well as a 26-year-old autistic man. We would just request that she be given a signature bond due to the lack of criminal history.
All right. I am going to and let me ask one last question. What was the relationship again, or do we know, Ms. Falk?
The only relationship stated in the warrant was that the two of them were living in the same household at the time of the incident. And the reason the state did not move forward on the cruelty was because there was no visible injury to support a battery charge, which is needed for the cruelty to child. But we do point out that this happened in the presence of a 3-year-old who then had to recount the incident to police officers.
Okay, gotcha. All right, I'm going to order the signature bond of $4,000. And I'm not gonna split it. I'm just gonna make it signature bond on both, 2,000 on each for a total of 4,000. Signature bond through pretrial. I am going to order the 1-day anger awareness course through pretrial. I'm going to order that stay away from 1026 Valley View Road Southeast. And I'm going to order no further contact with the victim, Elijah Duggar, and the minor PD. And no drugs, alcohol, or weapons while on bond. Did I leave off anything?
And I do believe that that was where Miss Shandy was living. So I would just request that the court advise her that she will have a specific time with an officer that she can go back and get her things.
Yes, I will order a one-time law enforcement escort to return to retrieve her personal items. You must go back with law enforcement, not by yourself, one time. And then she can get her personal belongings. Anything else?
Nothing further, Your Honor.
All right, thank you.
Next, we have position 22, Ms. Walton.
Okay. This is 22 CR 008229C, Marquetta Walton. You're charged in 1 count of terroristic threats and acts and a 2nd count of disorderly conduct. The offense date is December the 10th, 2022. Pre-trial.
She only has one prior arrest from April 20th, 2022 for fixing materials that reduce or increase light transmission of windows or window shields and possession of marijuana less than an ounce out of Clayton County. That case was dismissed. She is recommended for UJR.
Okay. All right, and is it ASG Select?
Your Honor, good afternoon. On December 10th, 2022, Officer was dispatched to 1760 Northside Drive in Atlanta. Officer Irving met with the victim in this case, Mr. Cameron Smith. Mr. Smith stated that he was delivering Amazon packages, and the defendant stepped in front of his truck and asked him where was his package. Mr. Smith advised that he was going to need a name for the package. And during the exchange, Mr. Smith advised that the defendant stated that she was going to beat his ass. He also advised that the defendant came onto the Amazon truck and appeared to be coming towards him in a threatening manner. Mr. Smith then continued to deliver packages, and one person that he delivered a package to, a witness in this case, Miss Chun Smith, and that's spelled CHUN-SMITH. Ms. Smith stated that the defendant was screaming. She witnessed the defendant screaming at the victim in this case, Mr. Smith, and accusing him of stealing her packages. She also observed the defendant climb up onto the Amazon truck and witnessed her stating that she would kick his ass as well. When Mr. Smith began to drive off, Ms. Chun Smith advised that Ms. Walton began to punch the side of his trunk repeatedly. Officer Irving ran a check on the defendant, and the defendant had a warrant out of Clayton County, and she was placed under arrest at that time. Although the defendant does have some limited history, we do have some concerns about her violent behavior and threats towards the victim in this case due to the nature of the charges and her threatening a delivery driver that probably has to come back to her neighborhood weekly or maybe on a daily basis. The state's recommendation at this time is going to be a $4,000 split bond, $2,000 surety bond on the terroristic threats, $2,000 signature bond on the disorderly conduct, no alcohol, drugs, or weapons while out on bond, no contact with the victim, and the witness as well, 1-day anger awareness. Nothing further from the state at this time.
Good afternoon, Your Honor. My client is 32 years old. She is gainfully employed. She denies the allegations as stated by the prosecution. In fact, my client said she was just talking to the Amazon driver because she had recently had some packages which went astray. He got very dismissive and disrespectful to her. And that was really what caused her altercation. She did not threaten him at all. That she denies. And she believes that the witness did not hear what was being stated, did not hear the conversation that we're having. And she denies that she climbed up on the truck, Your Honor. My client has no criminal history. She's never been convicted of anything. She's 32 years old. She's hardly a threat to the community. I would ask the court to give her a signature bond so she can get out of jail and get back home and get to work. Nothing further, Your Honor.
All right. I'm going to order the $4,000 signature bond through pretrial. And that'll be $2,000 on each charge. We're going to order the 1-day anger awareness course. I'm going to order stay away from 1760 Northside Drive.
She lives there, Your Honor. It's an apartment complex.
Oh, okay. That's right. Then I'll remove the stay away. Let me have no further contact, then order no further contact with the victim, Cameron Smith.
Thank you.
I know that he may have to go into that building. And if Miss Walton sees him coming, she should leave that area, or obviously make sure that she has no contact with this Amazon driver. I was almost going to say with any others for that matter, but I won't go as far. But they need to feel safe and be safe as they are trying to work and deliver their packages.
Your Honor, would you?
I'm sorry, no drugs, alcohol, or weapons while on bond. All right, anything else?
Yes, Your Honor. The state would ask that there be no contact with the witness as well, in this case, Ms. Chun Smith.
All right, I will add that, and no further contact with the witness Chun Smith as well.
Thank you, Your Honor.
All right, that should conclude that case.
Yes, Judge. Good afternoon. This is going to be position 5. He has a private attorney, Mr. Davis.
Okay.
Good afternoon, Judge. Attorney Michael Barber for Mr. Davis.
All right, hold on a second. All right, this is case number 22 CR 008223J. We got Britton Davis charged with 1 count of theft by taking. Pre-trial.
First arrest recommended for UJR.
All right. And, oh, Deputy Falk.
Yes, Your Honor. From November 25th, 2022 to December 9th of 2022, this defendant, who was an employee at 631 North Main Street in Alpharetta, the store is called Music and Arts. Officers were dispatched to that location where they were informed that this defendant, who was an employee, had taken audio equipment and a ukulele with a total value of $861.89. Loss prevention employees stated that the defendant admitted to taking these items. They further stated that Davis admitted that he took the items and walked them out to his vehicle over the course of the last couple of weeks. They also received an admission statement from the defendant. The recommendation is a $3,000 signature bond through pretrial services, stay away from the incident location at 631 North Main Street in Alpharetta, no alcohol, drugs, and weapons, and an anti-theft course.
All right. And go ahead, Mr. Barber.
Judge. Mr. Davis is currently waiting on acceptance into Kennesaw State University. He is transitioning over there. Prior to that, he had a very good GPA, Eagle Scout, marching band. He's currently living at home with his family in Milton, and he will be returning to that location with his parents. He's lived here his whole life. I think he's an excellent candidate for signature bond.
All right. Well, he is recommended, so I'm going to order that $3,000 signature bond through pretrial. I'm going to order that he stay away, and I'm assuming he's not working there any longer. I'm thinking that anyway. 631 North Main Street in Alpharetta. And to have no drugs, alcohol, or weapons while on bond. And I'm looking at this anti-theft class. I may not order it at this point because I don't know if we will have enough information together for him to choose such a class. Do you know of a class already, Mr. Barber?
I do not, Your Honor.
I thought the class was administered through pretrial services.
Pretrial, do you have the anti-theft class as well?
Yes.
Okay. All right. Well, I will order that anti-theft class through pretrial. It's part of the bond conditions. And anything else, counsel, that I need to take up?
Nothing from the state.
All right.
Your Honor.
What was the bond amount, Judge?
That was 3,000 signature bond through pretrial.
Thank you.
All right.
And Your Honor, I see an attorney, Gabe Banks. I just want to know who he's representing today.
I think you just put it in the chat. I just saw it.
I represent Tawuan O'Neill Brown.
Okay, let's see.
Thank you.
Come on, Mr. Brown.
That does conclude
Can we
my
do position number 14 first? If you all don't mind.
Not a problem.
We're fine. Yes, Mr. Barber, you're released. Thank you.
Thank you, Judge.
Okay. All right.
And excuse me, after position 14 is if the Spanish interpreter is on, we need another breakout session in courtroom number 3.
Okay.
For position 18.
Gotcha.
Thank you.
Thank you. And then now you want me to do 14?
Please.
Okay. This is 22 CR 8232Y. This is not for sure, and I don't want to mispronounce the name. We're just going to say last name is it Lee or Lie? L-I. You're charged with 1 count of simple battery, family violence. Offense date is December the 10th, 2022. Pre-trial.
I'm sorry, what position is this?
14.
Okay, give me 1 second.
Yeah. Okay.
Does the state have this history? I can't find that file for 14.
I'm showing a 2005 theft by shoplifting arrest and a 2014 driving without valid license arrest. Is all.
So you just have those 2 priors?
Yes, Your Honor. Did you want me to go ahead with?
Yes, go ahead and present.
Thank you, Your Honor. On December 10th, 2022, Officer Maloney was dispatched to the incident location at 4430 Pine Walk Drive in Alpharetta around 10:40 p.m. Upon officer's arrival, they met with the defendant in this case, who had blood on her shirt, and she stated that the blood on her shirt was from her son, the victim in this case. He is a minor, 16 years of age, and his initials are LD. The defendant stated that she was taking her son's dog up to his room so that he could take the dog outside. The victim refused to let the defendant bring the dog into his room. And according to the defendant, her son pushed her, but then grabbed her in order to stop her from falling down the stairs. At that time, the two separated. The defendant then stated she went back up to her son's room, but at that time, his door was locked. The defendant then kicked her son's bedroom door open, breaking the door frame and the door itself. And the victim stated that the defendant slapped him on the right side of his face. At that time, he attempted to grab her hands to prevent her from hitting him again, and that caused both of them to fall to the ground. The victim stated that during the fall is when he hit his nose on something and it caused it to bleed, and he was treated on the scene at that time. Due to this being a family violence incident between mother and son, we don't think that her slapping him was an appropriate form of discipline. What we know about the cycle of violence, the state would argue that she does pose a risk of reoffending, especially while they are living in the same household. This incident did occur on December 10th. Today is December 12th, so about 2 days ago. The state would be requesting a $3,000 surety bond, stay away from the incident location, no contact with the victim, no alcohol, drugs, or weapons, and a 1-day anger awareness. I do know that they are mother and son, and that they do live together, but that would be the state's recommendation at this time due to this event just happening a couple of days ago.
All right.
Yes, Your Honor. So this is obviously significantly more complicated than the state's presented because it is a mother and a son. Miss Lee has been struggling with her child, who is a teenager for some time. She was the one that called the police because he has been getting aggressive, very violent with her and other members of the family. At this time, his dog, which is a 140-pound dog, was becoming aggressive and rowdy, and she needed his help to get it under control. She's a mother of 4 children, 2 of which are babies. He would not come down from his room. She went upstairs with the dog to get him to take responsibility for his pet. He became very aggressive and shoved her down a flight of stairs, Your Honor. She was able to gain her composure, but the dog got away. She was very frightened for the small children, so she went and entered his room. She did enter his room because it's not just an anger issue. This child has threatened suicide in the past, and it's something that she's very aware of and very scared of. The state is charging Miss Lee with a simple battery offense, even though the statute that they cite very clearly states that in no event shall that subsection be applicable to corporal punishment administered by a parent or a guardian. Just because the state does not like that type of punishment does not make it illegal, and she should not have been charged for this. Miss Lee is a 38-year-old woman. She's a single mother to 4 children. She pays the bills with small side jobs so that she is able to be there with their family. She is the one that called for help. And she is beside herself not being able to be with her children. I'm not really understanding what the state is asking for when they're asking for for her to not be present in the home. That would mean that the children would go into de facto custody. We would ask, Your Honor, for a signature bond and for no further violent contact until this case is handled by the attorneys. But certainly not keep her from her own home and from her own children. Thank you, Your Honor.
And Your Honor, I just want to add that the presiding judge heard the facts and felt that this met the threshold for simple battery and not corporal punishment. And also in our report, the officer got the statement from the defendant saying that the victim stopped her from falling down the stairs, so she did not get thrown down a flight of stairs. The state was not aware of her having additional children or what the family structure was like in that home. At this time, the state is going to remain requesting no contact with the victim in this case. But I do understand the discretion of the court, Your Honor.
And that's a tough one. A 16-year-old, I'm assuming this victim is in high school and may or may not have a job and certainly is not self-sufficient.
Additionally, Your Honor, there is no father present in she's it.
Yeah, and that was going to be my next question. PD right about a father, grandparent, aunt, uncle, some other relative where this minor child could go stay while the bond is in place. We don't have any other family members.
There is an 80-year-old grandmother, Your Honor, but she does live in the home. This family doesn't have the kind of income that would allow for multiple living arrangements.
80-year-old grandmother in the home.
Yes.
State, have you all had a chance, and I don't know if you make a custom of talking to that victim at that age?
We have not had contact with the victim in this case.
Judge, the grandmother is actually here in our courtroom in the gallery.
Oh, really?
And Your Honor, due to the change in circumstances or just the new information that we have received from the defense, at this time, we wouldn't be opposed to a no further violent contact, just knowing that he doesn't have anywhere else to go.
Okay, thank you, State. I do appreciate that. Makes my job a little bit easier sometimes, I tell you. So what we're going to do then is order that $3,000 signature bond. And I'm going to order that, does he qualify pretrial?
No.
Okay, I will order the $3,000 signature bond through the jail. I'm going to order no further violent contact with the victim, LD. No drugs, alcohol, or weapons while on bond. And I guess that's all I can do at this point. Anything else that either counsel want to recommend to add to any of the bond conditions? I usually say sometimes when they are minors that they will continue to go to school while they're on bond.
The defendant isn't a minor in this case.
I'm sorry.
The victim that's a minor.
Okay. Scratch that. Sorry, I got that backwards. I apologize with the mom.
Nothing from me, Your Honor. Thank you.
Nothing from the state.
Yeah, that will be it. That should conclude this case.
Next, Judge, we have position 2, Mr. Brown, private attorney case.
Okay. This is 22 CR 0082221J. Is that Yomond Brown, charged with 1 count of battery. Offense date is 12/16/2021. And we have private counsel Gabe Banks.
Good morning, Judge, or good afternoon, Judge.
Good afternoon. How are you?
I'm doing well. Good to see you.
You too. So let's see. Pretrial, what do you have?
First arrest.
First arrest, okay.
Yes.
All right, and Deputy Falk.
Yes, Your Honor. This incident happened December 16th, 2021 at Pace Academy, located at 966 West Paces Ferry Road Northwest. Miletta Smith, which is Mileta Smith, stated that they were at her grandson's holiday program in the auditorium at Pace Academy when the defendant, who was her son-in-law, pushed her leg and sat on it, causing a very large bruise to her leg. Ms. Smith stated she did call the police, but did not want the defendant to be arrested at school in front of her children, and was advised by the officers to file a warrant at a later time, which she did. We have spoken to Ms. Smith. She stated that the defendant and her daughter are currently going through a divorce, and she stated that the defendant has continued to harass her since this incident last year. She further stated that they have a TPO hearing today. They had a TPO hearing today scheduled for 12 p.m., and she wants no contact with the defendant. I believe I saw Ms. Smith here on the Zoom if Your Honor wishes to sound for her. We are currently asking for a $2,000 surety bond. No further contact with Miletta Smith. Stay away from 2616 Oglethorpe Circle Northwest. No alcohol, drugs, and weapons. That's in large part because even though this is his first incident, according to Ms. Smith, there has been continuing contact and continuing harassment, which gives us cause for concern for influencing a witness. And that is the reason for the surety bond in this case. Nothing further from the state.
All right, Mr. Banks.
Judge, thank you. Good afternoon. On behalf of Mr. Brown, I would submit that he's been a law-abiding citizen his entire life. He's 42 years of age. He's a lifelong resident of the state of Georgia. He has one minor child, who is arguably the subject of this contentious custody dispute. I will say that these allegations occurred back in December of 2021. A TPO was filed back at that time, Judge, and actually a magistrate judge here in Fulton County heard the evidence and dismissed the petition, essentially saying that the allegations were not supported by the evidence. A year later, they come and file another TPO, and Judge, our contention is that his current wife, who he's in a divorce proceeding with, and his mother-in-law are doing their very best to essentially strategically plan that they get custody of the child and over his move for custody over a child. And so, Judge, I will simply say this: he's been law-abiding. There's no risk of him committing any additional felonies or misdemeanors for that matter. He's gainfully employed. He's the vice president of the Football Hall of Fame and has been so employed for quite some time. He's an active father. There is a separation order in place right now, Judge, where he actually they're week on, 1 week off, and the child always resides at the home, and so. There's been no issue until ultimately some hearings that have come up where they have strategically tried to position themselves in a better posture. But like the previous TPO, we believe that this TPO will also fall on deaf ears as well. Concerning his involvement with his child, though, he coaches all of his son's events. And so when I say this is a man who is actively involved, he not only talks the talk, but he walks the walk. I would ask for a signature bond, Judge, and that ultimately this court just reinforced that he abide by the current separation agreement. That has been working, and these allegations are old, and there has been no continuous harassment, not by him, and certainly there are two sides to every story.
And Your Honor, again, I would ask we sound from Loretta Smith to see if the victim wishes to speak in accordance with Marcia's law. I also wanted to give Your Honor the stay away address of 2616 Oglethorpe Circle Northwest. So we're not asking.
If I can just get clarity from the state, does the victim live at that address or does the victim live at another address?
The 2616 Oglethorpe Circle Northwest address was the address that we had on the warrant. If that is different, again, Ms. Smith can advise. So we're not asking for a stay away from Peace Academy. We're asking for a stay away from the address that was listed as the victim's address on the warrant.
Okay. Miss Meletta Smith? I
Yes,
think
yes,
she
Your Honor.
signed on. Yes, can you turn on your camera, please?
Yes.
Miss-
Good afternoon, Your Honor.
Yes, do you wish to address the court today?
I do, please.
All right, I need to swear you in first. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. And so the first question that we have for you, Ms. Smith, is what is your residential address? Where do you live?
Actually, it's 2616 Oglethorpe Circle Northeast, not Northwest. That's the only difference.
Okay. And who else resides there with you?
I live by myself. My daughter, because of the nesting, she will stay here on her off week out of the home.
Okay. All right. And are you in fear of Mr. Brown?
Absolutely.
Okay. And, but Mr. Brown does not reside with you. How close does he reside to you?
Their home is in Sandy Springs. But what occurs is when we're at events for my grandson, which I attend all the events, he just started coaching this year. The son is 7 years old and he had never been involved with any of his events up until this year. So if you go back beyond September, he never did anything. But what happened is when we are together, he comes in my space. I was at a soccer game. I was sitting to the right of the post. He came and walked up behind me. I moved to the left of the post and I have videos to show you. He stalked me there. I finally moved back to where I was. He came there again and came walking towards me at a fast pace, brushed my legs, brushed my arm and walked away. Most recently, November 5th, I was
I only want to talk about this December 16th incident.
Okay.
What happened on the 16th of December of last year?
I was at Pace Academy. My grandson was sitting on the aisle, my daughter in the middle, and I was in the third seat. Mr. Brown was sitting behind my daughter on the aisle seat. My daughter got up to take the grandson to the back. She placed her purse on the aisle seat. Mr. Brown got up out of his seat, came around into our aisle, moved her purse and sat there. And I told him that she was reserving that seat. She had put her purse there. So what he did was he said, "Don't talk to me." I said, "Don't talk to me." So my daughter walked up and asked him to leave the seat. So they went back and forth. He finally got up. And so they have the seats that when you stand up, they flip up. So when I stood up, he was exiting and I put my left leg over, it was a wooden armrest. And he comes back in the aisle. He pulls his arms back and pushes me back. So I start falling back. Then my legs are straddling the armrest. So he takes his left leg and presses and sits down. I weigh 115 pounds, Your Honor. He weighs almost 300 pounds. It created, and so I hit him on the back to get him off of me. So he leaves. He texts my daughter, that your mom hit me. And she said, "No, you pushed her. I saw you." And so when I got home, I did take photographs. That bruise stayed on my leg from December 16th all the way through April 25th. And I have doctor's notes. I have photos that I've taken every day. It was extreme. The doctor measured, it was 8 inches long, 3 inches wide was the bruise.
All right, but let me ask you this. You don't have an occasion that requires you to be around Mr. Brown. Is that correct?
Only when we go to my grandson's events.
But you all can sit separately and be separate in those events, correct?
Exactly. I would ask that he don't come into my space.
Okay. And let's see, is there any cross-examination by the state?
Your Honor, I would ask if Ms. Smith may be permitted to talk about the incidents that have occurred after this contact, because that is relevant to the Ayala factor of intimidating or influencing a witness.
All right, Mr. Banks.
I mean, it sounds like she talked about everything under the sun, including the size of her injury that she reported to her doctor. I'm not sure what else the court needs to hear regarding it, but if she wants to talk about it, I mean, I think the court is able to separate the wheat from the chaff to determine what the issue is here, and that's whether or not he's entitled to a bond.
All right, I don't want to belabor and go into a lot more incidents since this, unless again, this witness has told me that she's in fear of him and doesn't want to be around him. And I obviously will make sure to the best of my ability that they are separated, although I understand that she's the grandmother to the child in this case, and his, I guess, soon to be ex-mother-in-law. They have competing orders, I guess, in civil court, which would be Superior Court. And I think, Mr. Banks, you alluded to that. They already have an order in Superior Court, right?
They do, Judge.
Okay.
And I would just say that, I mean, while she's a grandmother, and I certainly respect that fact. I mean, I had a grandmother. I know in speaking with Mr. Brown's family, he respects that fact, notwithstanding some of the issues that have been raised, but his rights trumped hers. And frankly, to the extent that he has a right to be at his son's events, she does not. And so if she doesn't want to be around him at an event, while she can certainly be there, the reality is that he should not be required to leave his son's events simply because she is present. And so to the extent that the court enters a no violent contact or just a stay away, just that they avoid each other at these events, I think that would be appropriate in this situation.
Okay. I'm going to go ahead and rule if the state doesn't have anything else at this point.
Nothing further, Your Honor.
All right. I'm going to order a $3,000 signature bond, and I'm going to order that signature bond through pretrial. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to obviously order the defendant to stay away from 2616 Oglethorpe Circle. I don't think he has a reason to have to go there, but I will order the stay away from the victim's address.
Yes, Your Honor.
I'm going to order that there be no further contact with Meletta Smith. Although I heard, I think there was possibly a TPO pending, but they just need to stay away from each other. And I believe they can do that at these events for the grandchild, that she can sit on one end of the room and he can sit on the other. So, Mr. Brown, just make sure if you go to these events for your son, these activities, that obviously you have to stay away from Miss Smith. Just do not come near her in her space, and she's going to not come into your space so that you all won't have any contact with each other. And I think that is all that I can do at this point, because I don't order anything that's in conflict with the pending divorce orders that may be out, or separation orders.
Your Honor, my Zoom went out briefly. The state would request 1-day anger awareness if Your Honor hasn't already ordered that.
Oh, the 1-day awareness course through pretrial?
1-day anger awareness through pretrial services.
Correct. I will go ahead and add that to the order.
Well, and I understand the court's order, and I don't want to, challenge it at this point. Had the court not ordered, I would simply say he's presumed innocent at this point in time, and that this event occurred over a year ago, and now all of a sudden it's being drugged back to court again through a private warrant situation and a TPO. And interestingly enough, they had a hearing today, and he was arrested in front of his son, all of which he was trying to avoid. But to the extent that that's the court order, that's the court's order, Mr. Brown will abide by it.
All right. Thank you, Attorney Banks. We will keep the anger awareness course in the order for now.
Okay.
And I don't think there's anything else that I can do at this point. And so again, that's a $3,000 signature bond through pretrial.
Thank you, Judge.
All
Judge,
right,
I have
thank
a
you.
question, if I may.
Yes, yes, Ms. Smith.
How do I get notified when the actual court date is?
So
You're listed as a witness and Deputy Falk, I mean, the victim rather, and Deputy Falk can explain that to you.
Okay. Okay,
Ms.
thank
Smith,
you.
just like the victim advocate reached out to you today, you will be reached out to upon any additional court dates.
Okay, thank you. Thank you, Your Honor.
All right, thank you. Good luck to you.
Thank you, Judge. May I be excused?
Yes, you may. Thank you.
Thank you.
Go to another person.
Position 3, Bussey.
Okay. This is 22 CR 008121C. Almondo Bussey, you're charged with 1 count of criminal trespass. The offense date is December the 4th, 2022. Pretrial?
Yes. He has a total of 31 cycles. His last arrest was June 21st of this year for criminal damage to property in the 2nd degree, public indecency, and aggravated assault. That case does not have a disposition. I have to look in Odyssey for the case number. He has a 2017 conviction for sale, distribution of dangerous drugs, a 2015 conviction for 2 counts of theft by taking, a 2016 conviction for 3 counts of burglary, a 2008 conviction for aggravated assault, and then a 2005 conviction for battery. And a probation violation also from 2008. He had an aggravated assault from 2008. I believe I already read that one out too. A battery, family violence in 2003. And he did have a CWAC offense. I believe it was in the 90s because I see a probation violation for it. I was just looking for the actual date.
Okay.
I'm not showing it in the GCS.
We're showing an October 2007 offense under 07SC 62412 for rape, aggravated assault, false imprisonment, cruelty in the 3rd degree, battery, and possession of a firearm by a convicted felon. If that's the case you're referring to.
It's not, because it was the failure to register is in 2002 that I'm looking at, but I don't see the case before then, so nothing further.
Okay.
This incident happened December 4th of 2022. Officers were dispatched to 80 West Broad Street Food Depot in reference to a criminal trespass. They spoke with Miss Jessica Mercer, who advised that the defendant, who was an irate customer, refused to leave the store after he was asked to leave. The officers made contact with him, asked him for his name. He refused to identify himself. When another officer arrived at the scene, he actually recognized the defendant from previous instances, and the defendant was checked through GCIC and returned wanted out of Fairburn for criminal damage to property. That was an incident that happened on November 16th of 2022. The defendant also had a previous criminal trespass warning issued by Officer Russell on April 12th, 2022 from Food Depot. As you heard, Your Honor, this defendant has an extensive history, including this June 2022 criminal damage to property, public indecency, aggravated assault, where he's currently out on a $7,500 surety bond with an ankle monitor, and has an outstanding warrant from November of 2022 out of Fairburn. The state's recommendation is a $1,000 surety bond, stay away from the incident location at 80 West Broad Street Food Depot, no alcohol, drugs, or weapons. We also failed to mention the 2022 arrest for theft by shoplifting out of Fairburn PD as well.
All right.
Your Honor, my client is 43 years old. He has no children, is not married. He lives at home with his parents. He lives at home with his parents because he needs assistance. He is unable to work, Your Honor, because of disabilities that he has. He denies that the incident which happened at Food Depot was as reported by the prosecution. In fact, he tells me that he had been told in January of 2021 that he should not return to that location for a year. And he did not, in fact, return to that location in a year. He said there was something on his receipt that he wished to have clarified. And he was speaking to the cashier about it when she became belligerent with him and called the police. My client is not in a position to pay bond, Your Honor. I acknowledge that he does have some extensive history, but I would like the court to also take into consideration his disabilities, which are pretty extensive. He's in no position to pay for bond. I know it's not a high bond, Your Honor, but the fact is he still can't afford it because he's unemployed and he is unable to work. So I would ask the court to give him a signature bond for a number of reasons. First of all, this is a criminal trespass. This is a criminal trespass charge, which he denies. And he alleges that the officer told him something completely different and that he did not deliberately violate and stay away from the store. This is a grocery store after all, and he actually was there on legitimate business. I would ask the court to give my client a signature bond. He's been around in the jail, I think, for several days now, perhaps a week or so. And he's not a danger to anyone in the community, and he actually needs to be at home where he can get the care that he needs. Nothing further, Your Honor.
And Your Honor, I just want to point out that the defense has stated that he had been told to stay away from the location for a year, which according to them, they complied with. But Officer Russell's criminal trespass warning was issued on April 12th, 2022. So if we go a year out from that date, we're actually into April of 2023.
He denies that. He said it was January of 21. Mr. Bussey, you can call me after court.
Okay. All right. I'm going to order the $1,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order stay away from the Food Depot at 80 Broad Street, or 80 West Broad Street, I'm sorry. So please do not go back there, Mr. Bussey.
Now, can I say one thing?
Probably not. I think your attorney's going to want you to not make any statements against your interest, okay?
Yes, ma'am.
Unless you had a question about my bond condition.
No, ma'am, I don't. That's just a security bond. What is that? What does that mean?
We'll explain it.
Okay.
Oh, they'll explain the surety bond to you.
Thank you, ma'am.
Okay. And we don't have do we have a victim in this case? I wrote down a name.
Yes,
it's a supermarket.
Right. The individual that he was having contact with was Jessica Mercer. So we'd ask for a no further contact with her as well.
Okay, no further contact with Jessica Mercer. And that must be someone that works in the store.
That is correct, Your Honor. She is an employee at the store.
Okay, she's an employee. So if you don't go back to the store, you won't be violating your bond and you won't be able to have any contact with Miss Mercer, whether you know who she is or not.
I don't, but that's okay, ma'am. I won't approach that store anymore.
Okay, very good. All right, so that will, let's see, anything else, counsel, that I need to take up?
Nothing further.
Nothing from the state, Your Honor.
All right, that will conclude this case.
Thank you, ma'am.
Position 8, Hale.
This is 22 CR 008238A. Eric Hale, charged with 1 count of simple battery. Offense date is December 10th, 2022. Pretrial.
This is his first arrest.
And,
Judge, I'll be handling the case on Mr. Hale.
okay,
Attorney Sandra Wolf.
Sandra Wolf.
Yes,
All right.
Judge.
Welcome aboard. I don't think I've met you before, have I?
No, Judge, I do not believe we have met.
Okay.
This incident occurred on December 10th of 2022 at the location of 3390 Fairburn Road, Southwest Atlanta. On that particular date, Officer Mohammed responded to a dispute call at that location. And once he arrived there, he spoke with Mr. Eric Hale and also the alleged victim, Mr. Christian Henry. When he spoke with both parties, both of them advised the officer that they were in a physical dispute and had fought each other. And both noted by the officer, both parties had visible but small injuries. Grady did arrive to the scene and treated both for their injuries, and they refused EMS transport. At this time, the state is asking for a $2,000 surety with no further contact with the victim.
All right.
Your Honor, my client is 24 years old. As the state has pointed out, he's never been arrested. He is gainfully employed. He's been working at the same place for the past 2 years. He tells me that the cross defendant is someone who was living in the same household with him, although that person's name is not on the lease. My client's name is on the lease, which he shares with some other roommates, Your Honor. He would prefer the court to order no further violent contact between him and the cross defendant because he says it's just been a misunderstanding. They were actually staying in the same cell at the jail and they have spoke about it. And the issues between them have been resolved, Your Honor. I would ask the court to give my client a signature bond, given that he has no history, so that he can get out of jail and get back to work and his home. Nothing further, Your Honor.
Okay. All right, I'm going to go ahead and order a $2,000 surety bond.
Your Honor, my client has no history at all. He's never been arrested.
This is the first arrest.
Yes, Your Honor.
I just paid attention to a signature bond, $2,000 signature bond.
Thank you, Your Honor.
I'm going to order a stay away, the 3390 Fairburn Road.
That's his home, Your Honor.
That's his home.
Yes, and his name is on the lease.
Who lives there? All right, and then the victim though is, was it Christy or Chastity? Can't spell it. Hale. What?
It was Kristen.
Your Honor, if I may, it's Kristen Henry.
Kristen Henry. Okay.
Yes. And he's next on the calendar.
Okay. And so it looks like the roommate situation possibly, or?
Yes, Your Honor. And
It is, Your Honor. And
I
my
can-
client doesn't mind no further violent contact. That's what he tells me.
Okay. All right, no further violent contact. I may need to hear, I'm trying to decide who's going to reside there and who won't.
Well, my client's name is on the lease, but Mr. Henry's name is not. And my client has been living there for some time with two other people whose names are on the lease, but not Mr. Henry. He only moved in there in the past 3 months, that's my understanding.
The cross defendant.
That is correct, Your Honor.
All right, I'm gonna hold on.
Mr. Hale, call me later.
Yeah, I'm gonna hold on the stay away for a moment. It's Bridgewater, because I may, but certainly no further violent contact with the victim and the $2,000 signature bond through pretrial.
Thank you, Your Honor.
All right, that will, and I'm sorry, no drugs, alcohol, or weapons while on bond, if I didn't say that. And I will see if there needs to be a one-time escort or or stay away. Let me hold on that. But I'm also leaning towards the 1-day anger awareness course, but let me hear the second case real quick and then I'll make a final decision on both. So deputies, do we have Mr. Henry for next?
That's him right here in front of you, Your Honor. Position number 9, Mr. Henry.
Great. This is 22 CR 008240A. Christine Henry, charged at 1 count of simple battery, offense date December the 10th, 2022. Ms. Wolf, ASG Wolf.
Yes, Judge. It's my understanding, Mr. Henry, without us hearing from pretrial, Mr. Henry has 2 cycles. I believe one, there's no convictions on it. There's a prior arrest for, I believe, a theft by conversion. And then the second cycle is this case, Judge. As mentioned in the previous case, this is a incident that happened on December 10th at 3390 Fairburn Road. Officer Mohammed responded to that location and he met with Mr. Henry and the alleged victim, Mr. Hale. He spoke with both of them. Both of them basically told him the same thing, of which they were in a physical altercation. The officer did observe small but some type of injuries to them. They both got checked out and did not get transported to the hospital, Judge. In reference to Mr. Henry, we are also requesting a $2,000 surety bond. And if indeed they do reside in the same location, we wouldn't want to necessarily place a hardship on either one of them, especially since they really don't have, this gentleman has no significant history and the other one doesn't have one at all, of the bond being a no violent contact, because I understand the judge is considering that. We of course would also ask for the no drugs, alcohol, or weapons.
Okay.
Yes, Your Honor.
Go ahead.
This was a fight between friends that are also roommates. It is my understanding that neither one wants to kick the other from the residence, that they've spoken, that they are cool with each other, to use my client's words. I'm not sure what the lease situation is. I would ask for no further violent contact, but I would certainly ask that the court does not put a stay away on Mr. Henry. This is where he lives. And we would ask for a signature bond as well, Your Honor. He's never been convicted of anything. And even his past arrest has no violence whatsoever. Thank you.
Okay, I'm going to order the same $2,000 signature bond. And I guess the key now is to see Mr. Henry has somewhere else he can go reside while the bond is in place.
Your Honor, I don't believe he does.
I've been staying there for almost a year. Actually, it's now a year. It was since November of last year. My birthday of November last year.
Okay.
Your Honor, my client tells me that he's okay with there being no further violent contact, Your Honor. He doesn't want Mr. Henry to necessarily be on the street.
Well, the thing is, this happened 2 days ago, well, December 10th, but I still need to make sure that the victim is going to be safe, or I shouldn't say the victim, the co-defendant, cross-defendant rather. And I understand the only name on the lease would be Mr. Hale.
And 2 other people. Mr. Henry's is
2 other people.
Yes.
Well, I'm not gonna do a stay away from Mr. Hale. I'll just leave his order the way it is. But on Mr. Henry, Um,
Your Honor, they've also been in the same cell for the last couple of days.
really?
That's correct, Your Honor. Yes.
Well, with Mr. Henry, Mr. Henry, I'm going to order you to stay away from that location. See if you can find another place to stay. I'm a little concerned about putting you all back in this situation and just saying no further violent contact. I don't feel comfortable with ordering that. And so, Mr. Henry, if you can find another place to stay while on bond with friends, relatives, other, then that's what I'll do. So the stay away is with you, Mr. Henry, and to have no further contact, just as I ordered in the other case, no further contact with the cross defendant, Eric Hale. So they both have no further contact orders.
I thought it was no further violent contact for Mr. Hale.
Oh, no further violent contact. Okay. No further violent contact. So that'll be the same for both of them. But I'm going to order Mr. Henry to stay away and not Mr. Hale. Mr. Henry can have a one-time police escort or law enforcement escort to return to the property to retrieve his personal items with law enforcement. And that's what I'll do for each of the cases. Any questions or anything that's unclear, counsel?
No, Your Honor.
Okay.
No, Judge.
All right, thank you.
Judge, what type of, is it SOB through the jail or pretrial?
On Mr. Henry?
Yes.
On Mr. Henry, his will be $2,000 SOB pretrial as well.
Position 15, Matthews.
This is 22 CR 008239E, David Matthews, charged with 1 count of battery, family violence, 2nd count cruelty to children in 3rd degree, 3rd count of calls or other contacts, 911, and fails to hang up, and disengage connection for purposes of interfering with that 911. So all of those 3 cases, the offense date is May 22nd, 2022. Pre-trial. Oh, you're on mute. I think we can't hear you.
Sorry.
Uh-huh.
He has 18 cycles. He has 3 probation violations, 2010, 2021, 2022. He has a 2009 burglary conviction, a 2009 theft by receiving stolen property conviction, a 2011 theft by receiving stolen property conviction, a 2011 interference with government property, 3 counts of theft by shoplifting, willful obstruction of a law enforcement officer, aggravated assault against a peace officer, and participation in a criminal street gang activity conviction, a 2015 conviction for theft by taking and reckless conduct, a 2019 conviction for theft by receiving stolen property. He also appears to have a parole violation from 2015. He appears to have an open case. It's 15 SC 139562, and that was for possession of a controlled substance in Schedule 3, 4, or 5, and possession of marijuana less than an ounce. And nothing further. He may possibly still be on probation for the participation in criminal street gang from 2011, but I'm not sure if it's an active probation or not.
All right.
Nothing further.
Thank you. ASG, Ms. Campbell.
Yes, Your Honor. Good afternoon.
Good afternoon.
I would also like to add that in 2021, this defendant was arrested for aggravated assault and cruelty to children here in Fulton County. However, it was no pros, so it's not a conviction. I also have for that 2015 conviction that there was also a simple battery family violence charge attached to that. And so the facts as alleged for this defendant are that on the date of May 22nd, 2022, at the location of 5474 Oakley Industrial Boulevard, apartment 518, the officers did respond to this location and they did learn that the defendant arrived at said residence about 6 a.m. to retrieve his personal belongings due to relational issues with the victim in this case. Her name is Brandy, and that's Brandy, and her last name is Gillespie, Gillespie. Upon arrival, they did learn that there had been a verbal dispute between the defendant and the victim, and the defendant did become very aggressive with the victim, and he grabbed her by her neck. He held her very tightly, and it was to the point where she could not breathe. The defendant also struck this victim in her face, causing bruising to her eye, and the defendant further shoved this victim to the ground. The defendant also threw several items in the residence, causing broken glass. And so when the victim did go to call 911, the defendant snatched away all of her electronic devices and she was unable to call 911. The victim's father was also present in the home and he too tried to call 911, and the defendant also snatched away his electronic devices and precluded him from making a call to 911. The defendant, well, according to the father of the victim, the defendant has shown violent tendencies towards this victim previously several times. And so the state is very concerned about the victim's safety in this case. I'd also like to note that the police were only called after a neighbor called the police. So nobody in the home was actually able to call 911 as all of these terrible events were happening. And so based on the history, which includes an ag assault arrest from last year and a cruelty to children arrest from last year, as well as what the state believes to be a 2015 simple battery family violence conviction, in combination with all the prior convictions that this defendant has had within the past 10 to 11 years, it looks like at least 5 or 6. The state does believe he's also a risk of reoffending. So the state's recommendation for bond at this time is $10,000 surety, $5,000 surety on the family violence battery, $2,500 each on the cruelty to children, as well as the obstruction. It looks like there was a minor present in the home, and so that is why he has been charged with cruelty to children. Also, the state is recommending that this defendant have to stay away from the victim, Brandy Gillespie, as well as, no further contact with her, and stay away from the incident address, which is 5474 Oakley Industrial Boulevard, apartment 518, as well as have no alcohol, drugs, weapons while out on bond. Nothing further from the state.
Okay.
Your Honor, my client is 32 years old. He is the father of 5 children, a 13-year-old, 2 11-year-old, a 7-year-old, and a 2-year-old that he shares with the alleged victim. I was able to speak with Ms. Gillespie, and she tells me that what happened was a total misunderstanding. She says she continues to share her child with my client, who sees him often. While I acknowledge that my client does have significant history, Your Honor, this alleged incident happened more than half a year ago, I believe. The warrant states that it happened sometime in May. I would ask the court to take that in consideration when setting his bond. My understanding is there were no minors around at the time this incident happened, Your Honor, even though there are charges concerning the minors. My client tells me there were no minors there at the time that this happened. I believe Ms. Gillespie is on the Zoom. She did tell me that she would be appearing, Your Honor.
All right.
I am here.
Yes. And who is that speaking?
This is Brandy Gillespie.
All right, in order to speak, I need you to turn on your camera. I need to see you. All right.
Okay.
Would you like
Do
to
you think-
address the court today?
Yes.
Okay.
It was.
I need to swear you in first. Yeah.
Okay.
Raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay. All right, go ahead and tell me what you would like to tell me.
I don't wish to go further with the case. It was a misunderstanding. He did not take my stuff where I couldn't call 911. I left it in his truck. He had came and picked me up from some friends, and it was a misunderstanding. I never had my purse in the house. And he did not he did not hit me. He was trying to leave out, and I broke the mirror when he was going out the door. I knocked the mirror over. He was trying to leave because he's on probation. So what they're stating is not true. The neighbor just seen us outside arguing and he called 911. My dad, he never had a phone, or David never took his phone. We have a baby together and the baby was asleep. She woke up and he picked her up to keep her from the glass. So it wasn't an altercation where he hit me or anything.
Okay.
I broke the stuff that was in the house.
Okay. So then that goes to my next question. Are you in fear?
No, he's been picking up our daughter and everything since then. No.
How old is
I'm not in fear.
How old is your daughter with Mr. Matthews?
She's 2, and he also is a caregiver to my father. My father has dementia, so he takes him back and forth to his appointments, and he administers his medicine while I'm at work. So my dad didn't even talk to the police because he's not capable of, he's 75 and he also has Parkinson's. So I don't know where that came from.
Okay.
But my belongings were brought back. His mother did bring me back my belongings. They were I left them in his truck. He never took my phone or anything.
All right, I'm going to order a $8,000 surety bond. On the first charge, the battery, $5,000. On the second charge, $500 on the cruelty. And then $2,500 on the 911. Does that add up?
It does.
Okay, gotcha. I was making sure. Okay, and so that's the breakdown for the $8,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order a stay away. And who lives at this 5474 Oakley Industrial?
That's both of our home with our child.
Okay, I'm gonna have Mr. Matthews go find another place to live while on bond. So I'm gonna order that he stay away from 5474 Oakley Industrial Boulevard.
Okay, Your Honor, can I ask a question? So how is he supposed to get the baby? Because he picks her up every day.
You must have a third party to help facilitate that so that he doesn't come in contact with you to violate his bond conditions.
And what about my dad? Because he takes him to all his appointments. I'm not able to do it. He's his listed caregiver.
He can still do that and do it without coming into contact with you, or to have a third party to facilitate it, like with, if you do the visitation with your child as well as anyone else that he's a caregiver for in your home. All right.
Okay.
Does that conclude all matters, council?
Yes,
Yes, Your Honor. And just to clarify, that was a no further contact, correct?
Yes, I show it as no further contact.
Right.
And the state also did ask for anger awareness, in light of the fact that he has prior arrests for violent and aggressive behavior. This is not the first time he's been arrested for physically attacking other people. So the state was also asking for that anger awareness.
Your Honor, this incident happened in May. It's over 7 months ago. Ms. Gillespie has testified that that the incident did not go as reported in the warrant. She absolutely disputes what was said there. She has explained that he is the caretaker for her father, who has dementia, and that he is involved to a large extent with his child, who's 2 years old. This is going to cause a huge hardship to her. And she is the one who is allegedly the victim. I would, think that should be taken into consideration. This is going to make things a lot harder for her. She's expressed that she doesn't have anyone else to take care of her father. And, it's going to be a problem if she's not able to take care of his child also, Your Honor. So I would ask the court to reconsider the no further contact and make that into a no further violent contact, considering how long ago this incident happened and the fact that nothing further has happened between them since that time.
And Your Honor, the state would just be objecting to that. I mean, based on his history alone, he's a risk of reoffending. So the state does believe that Your Honor's ruling was very fair in light of his criminal history and his risk of reoffending, and considering the fact that what is alleged here is very serious violence against this victim. And whether she's denying it or not, his history says otherwise. So the state does believe that your ruling was very appropriate in light of what's been alleged here and in light of what his criminal history looks like. And I would withdraw my request for the anger awareness at this time.
May I speak?
Briefly, yes.
Okay, with the no further contact, I have to talk to him regarding our daughter. There's like nobody to intervene in between, and I work for the government. So I have to call him and he has to get her at a certain amount of time. So we're going to have to see each other. I help with the deployment of the soldiers and different things. So he is the primary caregiver, for her, because a lot of times I'm not around. And my job is very tedious with different hours. Sometimes I'm required to do overtime. So he's not a threat. We've been fine. I've seen him after the incident. My dad likes him around and he helps a lot. So he's not a threat to me. He did not strike me. That's not what happened.
Okay. Again, the surety bond is what we will go with. And you can have a third party to facilitate the visitation, like you said, your dad or another relative or friend, so that he will not.
Well, my dad has dementia, so he can't facilitate the visitation. Or I don't have
another person who can do it.
No, just the daycare, when he picks her up and he drops her off to the house, he brings her home, but he keeps her after daycare because I'm required to work after hours. So that's when I see him after hours. But there's nobody a third party that we go through.
I know you don't do it now, but is there someone that can assist you with it while he's on bond, so that I know that you and your child are safe and not still having that contact with him until this case is over?
I guess I could try to see if his mom could do it, but I'm not scared of him or anything like that. He's not a threat to me or my child.
Yeah, I understand, but we've had an incident that's still pending and open here. So that's
okay, understandable.
Right. So let's do third party transport and third party assist with visitation and picking up, so that you don't have to have any contact with him. And I don't know, does he need a one-time escort to get any items from the home, any personal items or clothing?
No, I can arrange for him to get it, for me to drop it to his mother. That's fine.
Okay, when he's not there. So again, that you don't drop things off and have to have contact with them, okay?
Okay.
Anything else, counsel? Did I
No,
say
ma'am.
no drugs, alcohol, or weapons while on bond?
I don't recall, Your Honor, but
Okay. I will
nothing
add
further
that
to
to
state.
order. And no further contact with Brandy Gillespie. All right. That will conclude this matter.
Thank you, Your Honor.
Position 19, Pitts.
Okay, he's at position 6. Are you Travis Dawson?
This is position 19, Pitts.
Oh, 19. I'm so sorry. I did not hear that. This is 22 CR 008234G, Daniel Pitts. Charged at 1 count of battery, offense date 12/10/2022. Pretrial.
Yes, 36 cycles. Last arrest was August 6th of this year out of Gwinnett County for theft by taking. That case does appear to be open for theft by taking out of Gwinnett. He also appears to be on probation in Huron County for theft by taking. This position was November of 2013, 5 years confinement, 5 years probation. Has 1 FTA from 2012, a criminal trespass conviction in 2019, a theft by shoplifting conviction in 2017, a theft by shoplifting conviction in 2016, interference with government property conviction 2013, a theft by taking and simple battery conviction in 2013, a willful obstruction of a law enforcement officer conviction 2012, a theft by shoplifting conviction in 2012, another theft by shoplifting conviction from 2012, a disorderly conduct conviction from 2009, and nothing further to add.
All right. ASG Campbell.
Yes, Your Honor. The facts as alleged for this defendant are that on the date of December 10th of this year, at the location of 639 Morosco Drive, which is a Chevron gas station, this victim and a third party did allegedly attack another male, and that male's name is Robin Brown. According to Mr. Brown and a third party witness, this defendant delivered a blow with a closed fist to his left eye. And so when the officers did arrive, they did observe a very deep laceration to the victim's face, and they did observe profuse bleeding to his face. The defendant did admit to the officer that he did punch.
The bond order.
The defendant did admit to the officer that he did punch the victim, and that essentially they got into a verbal altercation over cell phone use. And so in light of this defendant's criminal history, the state did count at least 9 to 10 prior criminal convictions, as well as the very serious nature of the allegations in this case, where the victim received a very serious injury. The state's recommendation for bond is going to be a $4,000 surety bond, a no further contact with the victim, Mr. Robin Brown, as well as a stay away from the location of 639 Morosco Drive, as well as anger awareness, if Your Honor is inclined to do that. But the basis for the bond recommendation is that risk of reoffense, as well as this defendant being a danger to the victim.
And what's the incident location again? 69 Morrow.
It's
Morosco.
639 Morosco, and I'll spell that for you. It's Morosgo Drive in Atlanta.
All right, Ms. McLeod, is this your case?
Yes, Your Honor, it is. My client is 34 years old, Your Honor. He tells me that this incident arose because he loaned his cell phone to the alleged victim, and he was going off of the cell phone. He kept asking him to return the cell phone, and he refused to return the cell phone. So he went after him just to retrieve his cell phone, and the alleged victim didn't want to give his phone back to him. And this was how they got into an altercation. My client, Your Honor, is currently he tells me, in a sober living facility. He's trying to get his life together. While we acknowledge that he does have some history, Your Honor, this was just a situation that he was trying to get his cell phone back from someone who was trying to improperly appropriate the cell phone after he had asked to use it on a pretext. And according to my client, this is just what happened. My client is not in a position to post money, Your Honor. He doesn't have any money. He tells me that he works from time to time through this program that he is in, but he does not have independent housing right now, and he really does not have the resources to pay a bond. I would ask the court to take that into consideration in setting a bond for him. Nothing further, Your Honor.
And Your Honor, just briefly, I don't know if pretrial mentioned, he does have a 2019 arrest for aggravated assault out of the cab, and I did not show a disposition for that. I'm not sure if it's still open. But the state is concerned about him, being a danger to the community as well.
All right. I'm going to order the $4,000 surety bond. I'm going to order that you, Mr. Pitts, to stay away from the Chevron at 639 Morosco Drive. Did I get that correct?
That's correct, Judge.
Okay. And I'm going to order, is it no further contact with, is it Robin Brown, Mr. Robin Brown?
That is correct, Your Honor.
Okay. No drugs, alcohol, or weapons while on bond. Anything else, counsel?
Nothing further, Your Honor.
Okay.
Ma'am, I would like to let y'all know that the aggravated assault for 2019 has been for some reason every time
I would advise you not to speak.
Sometimes every reason I get locked up, it still shows up. It's not, they didn't dismiss that. I've actually went back to prison afterwards and everything. It's nothing that they should, I don't know why that keeps popping up.
You don't have to talk about that because it doesn't concern your bond. Okay. My advice to you is not to discuss it.
Correct. All right. Anything else, counsel? I think that was it.
Nothing further, Your Honor.
Yes. All right. Thank you.
Position number 4 is next, please.
Okay.
Interpret the case.
Okay. And I thought earlier, did I see 2 interpreters on the screen?
Good afternoon, Your Honor.
Good afternoon.
Yes, it's 2 interpreter. Position number 4 at 18.
Okay.
I think I'm position number 18. I'm sorry.
Oh, okay. So it's the other one.
Yes, ma'am.
4 is it Campos de Oliveira? Is that the Portuguese interpreter?
That's correct.
It's me, Your Honor.
Okay. All right. And so raise your right hand for me and I'll swear you in. Do you solemnly swear or affirm that you will faithfully interpret from English to Portuguese and Portuguese to English, the proceedings before the court in an accurate manner to the best of your skill and knowledge with no embellishment?
I do.
All right, thank you. And I did get it right, Portuguese to English, correct?
Correct.
Okay. All right, I'll try to go a little slower here. This is case number 22 CR 0082222C, State versus Roberta Campos de Oliveira.
Este é o caso 22CR0082222C, do Estado versus Roberta Campos de Oliveira.
All right, and you're charged with 1 count of reckless driving.
A senhora está sendo acusada de condução de veículo, condução imprudente de veículo.
A 2nd count of driving on the wrong side of the road.
De ter dirigido na contramão.
The 3rd count of driving without a valid license.
E uma terceira acusação de ter dirigido sem carteira de motorista.
All with the offense date of 12/11/2022.
Sendo que essas acusações ocorreram no dia 11 de dezembro de 2022.
All right, pre-trial, go a little slow.
A audiência preliminar, por favor, vá um pouco devagar.
Only one prior arrest.
Só uma prisão anterior.
From August 22nd, 2021, out of California.
Na Califórnia, em 22 de agosto de 2021.
And the charge was alien removal under section 212 and 237.
E com relação à remoção de ilegal 212 e 237.
There's no disposition listed.
Não há nenhuma disposição listada.
All right, thank you. Let's see, Deputy Falk.
Yes, Your Honor. This incident happened on December 11th at 10:18 p.m.
Esse incidente ocorreu no dia 11 de dezembro, às 10h18 da noite.
The officer was traveling on Georgia State Route 400 southbound.
O policial estava dirigindo na rodovia Georgia 400 em direção ao sul.
When he observed a black Prius traveling northbound in the southbound lane.
Quando ele observou um Prius preto dirigindo na direção norte.
The vehicle passed the officer traveling at 65 miles per hour.
O veículo passou pelo policial a 65 milhas por hora.
And the officer entered onto the right shoulder in order to stop the vehicle approximately 50 feet from the Mansell Road entrance ramp.
E o policial, então, entrou no acostamento do lado direito para parar esse veículo, aproximadamente a 50 pés da Mansell, da Avenida Mansell.
Backup arrived and shut down Georgia southbound 400 to prevent an accident from occurring.
Reforços chegaram e fecharam a rodovia Georgia 400 em direção ao sul para evitar outros acidentes.
When the officer made contact with the defendant, he understood that she could not speak English and had her call a friend to translate.
Quando o policial entrou em contato com a ré, ele então percebeu que a acusada não conseguia falar inglês. Então, uma amizade, uma pessoa amiga, funcionou como tradutora.
Through the translation, the officer learned that the defendant did not have a driver's license.
Através dessa pessoa que ajudou com a tradução, o policial ficou sabendo que a ré não tinha carteira de motorista.
And she indicated she was driving on the wrong side of the road because it was dark and she couldn't see.
E ela indicou que estava dirigindo na contramão porque estava escuro e ela não conseguia enxergar.
The defendant also stated she was coming from the supermarket, but the officer didn't see any groceries in the car.
A ré também falou que estava vindo do supermercado, mas o policial não viu compras no carro.
I will state that the defendant did not show any signs of intoxication according to the officer.
Eu vou confirmar que a ré não demonstrou nenhum sinal de estar embriagada, de acordo com o policial.
And the state does have some concerns, however, due to the manner of driving, the fact that she did not have a license, and the fact that she seems to have little ties with this community.
E o Estado tem algumas preocupações por causa da forma como ela estava dirigindo, não ter carteira de motorista e ter poucas ligações nesta comunidade.
The state's recommendation is a $3,000 split bond.
A recomendação é uma fiança de $3.000.
That is 1,000 surety for the no license.
$1.000 referentes ao fato de estar dirigindo sem carteira de motorista.
1,000 surety for the reckless driving.
1.000 por causa da condução imprudente.
And 1,000 signature for the wrong way.
E o referente a 1.000, uma fiança não monetária por não manter a pista correta.
No alcohol, drugs, or weapons, and no driving without a valid license issued by DDS.
Não pode dirigir sem carteira de motorista e não pode usar álcool, ou drogas.
Nothing further from the state.
Não temos mais nada a acrescentar por parte do Estado.
All right, PD Holly.
Yes, Judge. First, I'd like to address the description that pretrial stated of a prior arrest in California.
Primeiro, eu gostaria de me remeter a essa descrição de uma prisão anterior na Califórnia.
Ms. Campos de Oliveira says that she has never been to the state of California.
A senhora Campos de Oliveira afirmou que ela nunca esteve na Califórnia.
And she did not enter the United States until August 29th of 2021, where she came directly to the state of Georgia from Brazil.
E que ela só entrou nos Estados Unidos em 29 de agosto de 2021, quando ela veio diretamente para a Geórgia.
In addition, Ms. Campos lives in Alpharetta with family.
Além disso, a senhora Campos mora em Alpharetta com a família.
She has 2 children who are with her here, 17 and 4 years old.
Ela tem 2 filhos aqui, um de 17, um de 4 anos.
She provides for them both by cleaning houses as a job while she lives here.
E ela sustenta a família limpando casas enquanto está aqui.
This incident was clearly an accident.
Esse incidente foi claramente um acidente.
She was following her GPS. It was dark and she made a wrong turn onto 400 southbound instead of northbound.
Ela estava seguindo o GPS, estava escuro, e aí ela entrou na mão errada na 400, na rodovia 400.
I'd also like to point out that not only was there no indicators of intoxication, but she actually took a breathalyzer and blew 0.0.
Eu, além de confirmar que não havia sinais dela estar embriagada, ela usou o bafômetro que indicou 0.0 de intoxicação.
In light of all this information, we would ask exclusively for a signature bond.
Então, à luz de todas essas informações, nós gostaríamos de solicitar apenas uma fiança não monetária.
All right. All right, I will grant the $3,000 signature bond, which is 1,000 on each of the charges. With that signature bond, I will order that through the jail. No drugs, alcohol, or weapons while on bond, and no driving unless she has a valid driver's license through DDS.
Ok. Então, eu vou definir uma fiança não monetária equivalente a $3.000, sendo $1.000 para cada uma daquelas 3 acusações. Não pode ter posse de drogas, álcool ou armas, e não pode dirigir sem uma carteira de motorista válida emitida pelo Departamento de Direção do Estado da Geórgia.
Okay. All right, anything else, counsel?
Mais alguma coisa, advogada?
Nothing further from the state.
All right, that will conclude this case.
Nada mais por parte do Estado, e isso conclui este caso.
Next position 18.
May the interpreter be excused, Your Honor?
Yes, you may. Thank you for your services.
Thank you.
Wait, this is an interpretation case.
I'm sorry?
See, this is an interpretive case.
Oh, but is this
Spanish.
Spanish or Portuguese? This is
Spanish interpreter.
Spanish.
Okay. Now I was releasing the Portuguese interpreter.
Portuguese. Please see.
That's okay. This is 22 CR 008235E. Is this Juan Picasso Castro?
Este es el caso número 22CR0082335E, señor Picasso Castro.
And I'm sorry, let me swear in. Madam Interpreter, please. Do you affirm that and swear that that you will faithfully interpret from Spanish to English and English to Spanish the proceedings before this court in an accurate manner to the best of your skill and knowledge and with no embellishments?
Yes, Your Honor, I do.
All right, thank you.
You're welcome.
All right, you're charged with 1 count of battery, and the offense date is December the 10th, 2022.
Señor, usted tiene un cargo de golpes y lesiones ocurrido el 10 de diciembre del 2022.
Free trial.
La Oficina de Servicios Previos al Juicio.
First arrest.
Es el primer arresto.
All right, ASG Campbell.
AGS Campbell.
Yes, Your Honor.
Sí, señoría.
Pre-trial is correct. This is his first arrest.
Los servicios previos al juicio dicen correctamente que es el primer arresto.
The facts as alleged
Los hechos, como se alegan,
are that on the date of December the 10th of this year,
ocurrieron el 10 de diciembre de este año
at the location of 5615 Ashwood Downs Drive,
ocurrieron en el lugar del 5615 Ashwood Down Drive,
located in Alpharetta.
localizado en Alpharetta.
This defendant was driving an Uber.
Este acusado estaba manejando un vehículo para Uber.
And he did punch his passenger.
Él abofeteó a su pasajero
in the face,
en la cara,
causing pain and visible swelling.
Causando dolor y inflamación visible.
The defendant admitted to the officer
El acusado admitió a la policía
that he punched the victim,
que abofeteó al pasajero,
whose name is Brian,
cuyo nombre es Brian
Epp, EPP.
EPP.
The punch was incited by the passenger closing the defendant's trunk too hard.
La bofetada se ocasionó debido a que el pasajero cerró la cajuela muy fuerte.
The state's recommendation for bond is a $2,500 surety bond.
La fianza que recomienda la fiscalía es de $2,500 bajo garantía.
On the sole count of battery.
Y en el único cargo de golpes y lesiones.
No further contact with the victim.
No tener más contacto con la víctima.
And to stay away from the victim's address.
y mantenerse alejado del domicilio de la víctima.
which appears to be the incident location.
Lo que parece, el lugar que parece ser donde ocurrió el incidente.
Nothing further from the state.
Nada más de parte de la fiscalía.
All right. Ms. Kim? PD
Yes,
Kim?
Your Honor. Señora Kim.
Mr. Picasso Castro
El señor Picasso Castro
is 45 years old, Your Honor.
tiene 45 años de edad, su señoría.
And, no, 39 years old, my bad.
Perdón, 39 años de edad.
And he has been here in Georgia for the last 19 years.
Él ha permanecido aquí en Georgia durante los últimos 19 años.
And he has been driving his Uber for about 1.5 years, ever since pandemic.
Y él ha manejado para Uber durante 1 año y medio desde que empezó la pandemia.
And indeed, he has been an excellent excellent Uber driver with a high rating.
Él en realidad ha sido un conductor excelente con alta estima.
My client was basically defending himself from perceived attack by angry customer.
Mi cliente se tuvo que defender perseguido por un irascible cliente.
And I believe that he is qualified for a signature on bond.
Yo creo que él cumple los requisitos para recibir una fianza no monetaria.
This is his first offense ever.
Este es su primer delito que ha cometido en su vida.
And he is not qualified for public defender's service, so my representation will end at the end of this bond hearing.
Si no cumple los requisitos, mi pedido es que se termine el servicio mío de representarte al finalizar la audiencia.
He has been also married with one minor child.
Él ha estado casado con un hijo menor.
And he has been a good law-abiding citizen for the last 19 years in Georgia.
Él ha sido un buen ciudadano durante los 19 años aquí en Georgia.
Thanks, Your Honor.
Gracias, señoría.
All right. I'm going to order the $2,500 signature bond through the jail.
Yo voy a ordenar una fianza no monetaria de $2,500 a través de la cárcel.
I'm going to order stay away from 1515. Is it Ashwood Downs Drive in Alpharetta?
Your Honor, it is actually 5615 Ashwood Downs Drive, and Ashwood has an E on the end.
Okay, thank you. Sorry about that. Got those numbers there.
Voy a ordenar que se mantenga alejado de la dirección 5615 Ashwood Down Drive en Alpharetta.
And was there, did the state request no further contact?
Yes, Your
¿La
Honor.
fiscalía ha pedido que no haya más contacto entre ellos? Sí, su señoría.
And give me that name again.
¿Me puede dar el nombre de la víctima otra vez?
Brian Epp, and Epp is spelled E-P-P.
Brian Epp, y el apellido Epp es E-P-P.
Okay. And no drugs, alcohol, or weapons while on bond.
Queda prohibido el uso de drogas, alcohol y armas mientras esté libre bajo fianza.
And I think that's it. Anything else, counsel?
Creo que eso es todo. ¿Algo más, licenciada?
No, Your Honor.
No, su
Nothing
señoría.
further from defense.
Nada más de parte de la defensa.
All right, that'll conclude this case.
Esto concluye este caso. Your Honor, I had other names that were sent to me as possibly defendants that may need help.
Uh-huh.
But I would like to confirm that through you, please.
Okay. Deputy, do we have any more
Yes,
defendants
Judge,
and
it's the
interpreters?
next case that's what we're doing now, Gonzalez, add-on position 1.
Add-on position 1 is Spanish interpreter.
And then we also have a visitor for him in the gallery.
And is there another case as well, Deputy?
No, this is the last case.
This is the last case? Okay. All right. Thank you. This is position 1, add-on 22 CR 008243B. State versus Ernesto Manuel Gonzalez.
Este es el caso 22 CR 008-243B, Ernesto Manuel González.
Charged with 1 count of driving improper erratic lane change.
El cargo es por manejar de manera errática e incorrecta al cambiarse de carril.
Second count of driving hit and run.
Y el segundo cargo por conducir, chocar y huir.
And I have a third charge, but I'm not sure.
Y tengo un tercer caso que no estoy segura cuál es.
And it was duty of driver to stop at or return to the scene of an accident.
Es por incumplir con la obligación de regresar a la escena de un accidente.
With the offense date of February the 25th, 2022.
Con fecha de 25 de febrero del 2022.
All right, pre-trial.
Los servicios previos al juicio.
He has 4 cycles.
Él tiene 4 ciclos.
Last arrest was October of 2019 for failure to appear.
El último arresto fue en octubre del 2019 por no comparecer ante el tribunal.
That was out of Florida.
Y eso fue en el estado de Florida.
He has an arrest from 2016.
Él tiene un arresto del 2016.
For alien inadmissibility under section 212.
Y por inadmisibilidad por residencia ilícita de la sección 212.
That case appears to be open. There's no disposition listed.
Y ese caso se ve abierto sin ningún dictamen hecho todavía.
And nothing further.
Y nada más.
Okay.
Good afternoon, Judge, again.
Buenas tardes de nuevo, su señoría.
My understanding is there should really just be 2 counts. It should be the erratic lane change, and then the hit and run involves the whole thing of leaving the scene and not returning.
Gotcha. Okay.
Creo que el cargo es solo por manejo errático y el cambio incorrecto del carril, pero el cargo de chocar y huir y incluye también el haber incumplido en regresar al lugar del accidente.
The alleged facts of this case is that on February 25th, 2020,
los hechos alegados realizados el 25 de febrero del 2020
at the location of 1841 Piedmont Road, Atlanta, Georgia,
en el lugar domicilio 1841 Piedmont Road, Atlanta, Georgia.
Then an officer was called to respond to that location.
Un oficial recibió la llamada para que se dirigiera a ese lugar.
And he met with the victim, Madeline Verla Turo.
One moment, please. Verla Turo.
I believe it's VARELA-TORO. So I probably said it.
El oficial se reunió con la víctima Madeleine Verla Toro.
The victim stated that she was exiting the property when her vehicle was struck by someone entering the property.
Que indicó que ella estaba saliendo de la propiedad cuando un vehículo golpeó su propiedad.
The victim stated that the person that hit her left the scene and she followed them.
La víctima también declaró que la persona huyó y la víctima lo siguió.
That person eventually did stop. And once the person stopped, the victim took photos of the person and the person's vehicle.
La víctima declaró también que la persona eventualmente se detuvo y una vez que hizo eso, la víctima tomó fotos.
Officers were able to identify Mr. Ernesto Gonzalez from the photos provided by the victim in the case.
Y la policía pudo localizar al señor Ernesto González a través de las fotografías que proveyó la víctima.
The only additional thing that I have that was not mentioned by pretrial is, I believe,
Lo que no creo que fue mencionado por los servicios previos al juicio, creo que es
that there was a driving while license suspended in 2018 arrest.
Que había un cargo de manejar con una licencia suspendida en el 2018.
At this time, it's the state's belief that Mr. Gonzalez is a danger to the community.
En este momento, la fiscalía cree que el señor González es un peligro ante la sociedad.
And that once hitting the victim in this case, which was via a driveway that he fled the scene.
Porque en cuanto golpeó a la víctima alegada en este caso, en el lugar que fue en realidad una cochera, en donde estaba el carro.
Additionally, the state is concerned with him possibly not returning for a court date. He does have that 2019 failure to appear out of Florida.
Además, la fiscalía tiene la preocupación de que este acusado no comparezca ante el tribunal, ya que tiene un incumplimiento por comparecencia en el 2019 en el estado de Florida.
And with having the fairly recent incident out of Florida, the state is unsure if the defendant has any ties with the community in Georgia at all.
Y debido a esta falta de comparecencia en el estado de Florida, la fiscalía no está segura que este acusado tenga conexiones o esté ligado a familiares en el estado de Georgia.
The state is requesting a $3,000 surety bond on the hit and run charge.
La fiscalía pide una fianza de $3,000 bajo garantía por el cargo de chocar y huir.
And a $500 surety bond on the erratic lane change, improper lane change.
Y $5,000 una fianza de garantía por el cargo de manejar de manera errática haciendo un cambio equivocado de carril.
No contact with the victim and no drugs, alcohol, or weapons during bond.
Que no haya más contacto con la víctima y quede prohibido el uso de drogas, alcohol y armas mientras esté bajo fianza.
Nothing further, Judge.
Nada más, su señoría.
So I'm going to grant the.
Judge, may I be heard?
I'm sorry. I apologize.
Podría.
Go ahead, PD Holly. I apologize.
Mr. Gonzalez has lived in the state of Georgia for 3 years. He works full-time for DoorDash, delivering food.
El señor González vive en Georgia y ha trabajado por 3 años, 3 years.
He works for DoorDash, delivering food full-time.
Trabaja para DoorDash, haciendo entregas de comida.
He lives with his girlfriend, who is currently pregnant and is due in less than 2 months.
Él vive con su novia, quien está embarazada y va a tener un bebé en 2 meses.
I believe that's a very strong tie to this community, especially because he has a family and this will be his first child.
Yo creo que eso implica gran conexión en la comunidad, ya que tendrá una familia y su primer hijo.
As the state mentioned in their description of what happened, Mr. Gonzalez was not at the scene of this accident.
De acuerdo a lo que declaró la fiscalía con respecto a lo que hizo, lo que pasó, el señor González no estaba en el lugar de los hechos.
And when the officer called him to speak with him, he was not able to communicate with Mr. Gonzalez because of the language barrier.
Y cuando el oficial pidió hablar con él, el acusado no pudo hablar debido a la barrera de lenguaje existente.
But according to the officer's report, Mr. Gonzalez found a friend who could translate and immediately called back to try to understand what was going on.
De acuerdo al informe policial, el señor González llamó a un amigo quien inmediatamente contestó para ayudar en la comunicación de ellos.
And the officer in his report admits to hanging up on Mr. Gonzalez when he became, quote, confrontational, despite the fact that he wasn't speaking directly with him.
Y el oficial admite haber colgado con el señor González cuando se vio en una actitud frontal debido a no poder comunicarse claramente.
Judge, I believe Mr. Gonzalez has plenty of ties to this community.
Señora jueza, yo creo que el señor González tiene fuertes conexiones en esta comunidad.
And I would request that he be given a signature bond so that he can bond out and continue to provide for his family and soon to be here child.
Y por eso yo solicito que se le otorgue una fianza no monetaria para que él pueda continuar proveyendo para su familia y su futuro hijo.
All right, anything else, counsel?
Yes,
¿Algo
yes. Yes, Judge, just briefly.
Sí, algo muy breve.
In that same report, it indicates that when via the help of someone else, the defendant spoke with the officer, he denied the accident.
Existe también en ese mismo informe que cuando el acusado recibió ayuda de alguien, él negó el accidente.
And additionally, we asked the court to consider that defense counsel has stated that.
Y también la petición que ha hecho la defensa, se ha establecido que
that the defendant actually drives for his employment.
Que el acusado maneja para trabajar.
That concerns the state in that this incident was a driving incident and involved him hitting someone and leaving the scene of that accident.
Eso preocupa a la fiscalía porque fue un incidente en el que el acusado iba manejando y dejó el lugar de los hechos, huyó.
Thank you, Judge. Nothing further.
Gracias, su señoría, nada más.
Your Honor, as the state said, he denies those allegations at this time.
Como la defensa estableció antes, el acusado niega esos cargos.
Okay. I think I'm going to order
Creo que ordenaré
the $3,000
$3,000
signature bond through the jail.
$3,000 de fianza no monetaria a través de la cárcel.
And that'll be on the driving improperly erratic change. That will be $500 and then $3,000 on the hit and run.
Y por manejar de manera errática con un cambio del carril incorrecto serán $500 de fianza y los $3,000 por el cargo de chocar y huir.
Judge, will you say that again? Is it a total $3,000 SOB through the jail?
Yes, ma'am.
Okay, so that's $500 on the improper and then $2,500.
Oh, yeah. Fix my math there, yes. and
Okay.
En realidad fue un total de $3,000 por ambos. Serían 2,500 por chocar y huir y 500 por manejar de manera errática. Sí, es correcto.
And no drugs, alcohol, or weapons while on bond.
Se prohíbe el uso de drogas, alcohol y armas mientras esté libre bajo fianza.
And I guess that's it, counsel. Anything else?
Creo que eso es todo, licenciada. ¿Algo más?
Not on behalf of the state.
No de parte de la fiscalía. Y
And that
no de
should
parte de la
conclude this
defensa.
case. Right, and that should conclude this case.
Entonces esto concluye el caso.
Thank you.
Gracias. So I can be dismissed, Your Honor. Is that correct?
Yes, that is correct. Thank you.
Thank you. Have a good day.
You too.
Thank you.
Position 23, Wilson.
All right, this is 22 CR 008231D, Gene Wilson, charged with 1 count of criminal trespass and a 2nd count of willful obstruction of a law enforcement officer. Offense date is December the 11th, 2022. Pre-trial?
2 cycles. Last arrest 2005 for possession of cocaine with intent to distribute. That case was dead docketed. The first arrest was an interim auto from 2004. There's no disposition listed on that case. He's recommended for UJR.
All right. And is it ASG Select?
Yes, Your Honor. On December 11th, 2022, Officer McGow with the Atlanta Police Department was dispatched to a Shell gas station at 3601 Martin Luther King Jr. Drive. Upon arrival, officers initially tried to speak with the defendant, but he became loud and belligerent. Officers then spoke with the store clerk, Mr. Multani, M-U-L-T-A-N, and he stated that he believed that the defendant was intoxicated and that he wanted him to leave the store. Officer McGow attempted to speak with the defendant again. The defendant began running toward the sidewalk and stated that he was not going to allow the officer to grab him and that he knows his rights. The officer McGow asked the defendant to leave the premises. The defendant then stated that he was not going to leave, and if he was arrested, that he would be out the next day. The defendant continued to stay on the property after being told to leave the premises and started to harass customers that came onto the property and was telling customers to leave the location. Officer McGow asked the defendant to go home again one more time, and he continued to refuse. The defendant was advised to place his hands behind his back while attempting to place Mr. Wilson in cuffs. The officer and defendant both fell to the ground. The defendant then ran towards MLK, fell to the ground, and was actively resisting arrest. Mr. Wilson grabbed the handcuffs. He was kicking his feet. He was rolling over. Officer McGow then dispatched for assistance, and another officer came out to the scene, and they were able to successfully place him into custody at that time. Due to the defendant's own statement saying that he would be out of custody the next day, the state would argue that he does not take the court seriously or the system seriously as well. He does have 2 prior arrests, although remote. In this instance, he was acting belligerent towards officers, not following instructions. The state at this time would be asking for a $500 surety bond on each charge, no alcohol, drugs, or weapons while out on bond, and to stay away from that incident location. Nothing further from the state at this time.
All right. PB Kim?
You muted, Kim.
I apologize. It was muted. Mr. Wilson has been here in Georgia for the last 30 years. He has a 1 minor child who's only 14 years old right now, and he has to be financially responsible. He has been working as a home chef as a full-time. He does a lot of production for the chef as a chef. However, he lost his job about a week ago. So at this point, he's not really qualified for public defenders, but he may become qualified for public defender service if he cannot find a job soon. He does have a GED, and he does have a place that he resides with his girlfriend. He has a strong ties to the community. He's not a flight risk, and I think he is qualified for signature on bond for this charge, Your Honor. Thank you.
All right. Anything else, counsel?
No, nothing further.
I'm going to order that $1,000 signature bond through pretrial. So that'll be 500 on each of the charges. I'm gonna order stay away from the Shell station at, is it 3601 Martin Luther King Drive?
Yes, Your Honor.
And did you all ask for a no further contact? State, I don't think you did.
I did not initially, Your Honor, but if you are inclined to do a no contact with the store clerk, Mr. Multani, that's spelled Multani.
Yes, no further contact with Mr. Multani. And no drugs, alcohol, or weapons while on bond. And I think that should conclude this case.
Thank you, Your Honor.
Mm-hmm.
Number 17 is next in courtroom number 3, please.
Okay.
I'm sorry, Your Honor, can we give the bond amount for position number 18, Mr. Picasso, so I can take them back?
Okay, let's see. What do you have, Ms. Bridgewater? 2,500 SOB jail?
Yes, just give me 1 second to get to that.
Okay. Let's confirm, make sure I've got it written down.
Okay, I'm gonna get it right. Just 1 second. It is position 18, 2,500 SOB through the jail.
Thank you.
You're welcome.
She's waiting on you.
I'm sorry.
Judge, you're waiting on the next case, right? It's gonna be a courtroom 3.
Oh, okay, courtroom 3. Okay, who do we have?
17, Judge.
Okay. This is 22 CR 008241E. Nayla Mohammed, charged with 1 count of simple battery family violence and a 2nd count of battery family violence and a 3rd count of criminal trespass, all with the offense date of December the 11th, 2022. Pretrial.
She has 3 cycles. Last arrest was for simple assault from May of 2018. There is no disposition listed on the GCRC. Actually, I went in Odyssey. That was a conviction for simple assault and 2 counts of disorderly conduct in 2019. And the other two arrests are both theft by shoplifting in 2015. One was dismissed. The second one doesn't have a disposition. And nothing further.
All right. Oh, I'm sorry, ASG Campbell.
Yes, Your Honor. The only additional information I have for the history is that it looks like one of the 2016 theft by shoplifting was a conditional discharge. So a manner of probation. And as to the facts alleged in this case, on the date of December 12th of this year, which was this morning at about 1:25 a.m. at the location of 1110 Hammond Drive, there was a call for domestic dispute. Officers did respond. Upon arrival, they did observe this defendant actively throwing a plastic organizer at the victim in this case. His name is William Arnold, traditional spelling. They did observe that plastic organizer strike the victim in his back as he was walking away from this defendant. He and the defendant are in a romantic relationship and they live together. They did speak to the victim and he further advised them that the defendant actually bit him in the arm and that she also scratched him several times. And they did observe a bite mark to his arm as well as several scratches on his cheek. They also learned from the victim that this defendant broke several of the victim's items within the home, including his iPad. So that was what gave rise to the criminal trespass charge. As pretrial mentioned, this defendant just completed probation for simple assault back from a 2019 conviction. That does not involve the same victim in this case. It was a female victim, but what the state does believe based on that prior conviction, as well as the violence alleged in this particular incident, is that this defendant is a risk of reoffending, as well as a danger to this victim and to the community as a whole. So for that reason, the state's recommendation for bond is a $5,000 total surety bond, $3,000 on the family violence battery, and $1,000 each on the remaining counts. The state is also recommending a stay away from the incident location of 1110 Hammond Drive, as well as no further contact with the victim, William Arnold. Nothing further from the state.
All
Your
right.
Honor, my client is 24 years old. She was actually the victim of an assault here, Your Honor, and a battery. She tells me that her boyfriend, and they do not live together, Your Honor. I'd like to put that on the record. This is my client's home. This is her apartment. He does not live there. He was merely visiting. He assaulted her. He threw his laptop and hit her. In fact, she tells me she had to go to the hospital. She was, her shoulder was dislocated. She had to be taken to the hospital. And she also has a cut on her face. She went to Grady, Your Honor. He was the one who attacked her. My client is employed, Your Honor. She has no significant criminal history. I would ask the court to take that into consideration. And also the fact that for some reason, the boyfriend was not arrested, even though he was the one who attacked my client. He threw his laptop and hit her so that, as I said, her shoulder was dislocated. I don't know why it does not say that she was taken to Grady Hospital, but she was taken to Grady Hospital, Your Honor. And if the court looks closely, you will see that my client has bruises to her face where this man attacked her. Based on that, Your Honor, I would ask the court to give her a signature bond. Her record is not such that she should not qualify for a signature bond, Your Honor, so she can get out of jail, get on with her life, and go back to her home. He does not live there, Your Honor. And she would like a stay away, for him to stay away, because this is her home. Nothing further, Your Honor.
Okay.
And Your Honor, just briefly in rebuttal, I would like to add that the officers did try to speak to this defendant about the incident, and she actually refused to cooperate with them. She actually refused to allow the officers to enter the home. And they tried to get a statement from her. They tried to speak to her, but she refused to cooperate. And I would just like to add that the officers saw this defendant throw an object at the victim while the officers were present at the location. So that further goes to the state's theory, which is that this defendant does pose a danger to this victim, who is the male William, or Mr. William Arnold.
I think it's undisputed, Your Honor, that my client was injured. She was taken to Grady Hospital. She had to have X-rays, MRI, and that she has injuries to her shoulder and also to her face. And they certainly were not self-inflicted.
Well, the officers didn't observe any injury to her. That's not in the warrant packet. What is in the warrant packet is that they observed injury to the victim, Mr. Arnold.
That doesn't mean she was not injured. The fact that I think my client should not be penalized for the fact that she chose not to speak with the police. She was in pain. She had just been struck with a laptop and something else. You know, her shoulder was hurting, her face was bleeding. I'm surprised that the police officers did not observe any of that.
And she had also just completed probation for simple assault from 2019 on another person.
That doesn't mean she was not a victim here.
Okay, I think I will go ahead and order the $5,000 surety bond. That will be $3,000 on the battery and $1,000 on the other two. That'll be the breakdown. No drugs, alcohol, or weapons while on bond. Stay away from 1110.
You know, that is her home. He does not live there.
Okay, so I will take off the stay away, but let me add this condition is that the victim can reside there. I'm sorry, the defendant, which one did you say?
This is my client's home, Your Honor. He does not live there. He was merely visiting when this alleged incident took place.
Okay, he was just visiting. Okay, so we'll
Yes,
take out the stay away, but no further contact with the victim.
Thank you, Your Honor. This concludes my business before the court. May I be excused?
Yes, you may. Enjoy the rest of your day.
Thank you, Your Honor. You too.
Position 13, King.
Okay. This is 22 CR 008233Y, Demarius King. Charged with 4 counts, the first being driving, hit and run. Second count, duty of a driver to stop at or return to the scene of an accident. Third count, driving while license suspended or revoked. And the fourth count, willful obstruction of law enforcement officer. And is that fifth charge dropped? What happened to the unlawful to possess, display, or use any false, fraudulent, altered identification of documents? Has that been no pros?
Let me double check, Your Honor.
Okay.
I believe that charge was filed.
Oh, so are there 4 or 5?
There should be a total of 4. Only 1 count of unlawful to possess, display, or use any false, fraudulent, or altered identification document.
Okay, so then I have 5, it looks like on my calendar, I think, do I?
Well, I believe there should be one, so I'm sorry about the discrepancy. Just one count of that.
Okay. And so tell me which counts you have.
I have that he has the hit and run, he has driving while suspended, and he has obstruction, as well as possession of a false or fraudulent identification document.
Okay, so you don't have an obstruction.
Your Honor, there is an obstruction. It's the third charge. So driving hit and run is 1, driving while license suspended is 2, willful obstruction is 3, and the false identification documents is 4.
That's correct, Your Honor.
All right, so you don't have duty of a driver to stop or return to the scene of an accident. That's the one you don't have.
That's still part of the hit and run.
Yes,
Gotcha.
Your Honor, that tends to
Okay.
get treated
Part of
like
the hit and run.
counts, but it's all part of the same.
Gotcha. Because the way it's kind of written on the calendar, I've got that semicolon there, which usually tells me it's a different charge. All right, with the 4 charges that we have, the offense date is December the 9th, 2022. Pretrial,
Has 2 prior cycles, with the last being out of DeKalb County from October of 2021 for identity theft, fraud when using or possessing identifying info concerning a person. That's an open case. He has another open case, which is the first arrest out of Fulton County for financial transaction card theft, driving, failure to place decal on tag, and driving while license suspended or revoked. 21 CP 203 643, and nothing further.
all right.
Yes, Your Honor. And as to his history, I would also like to add that he does have convictions on his driving history for erratic lane change, speeding, a seatbelt violation, and a serious offense by a person under 21. It's my understanding that he's 21 now or 22. So these are all recent. I would also like to add that he has 2 FTAs on his driving history. The most recent FTA being from May 13th of this year, as well as a June 14th of last year FTA in traffic court. The facts as alleged for this defendant are that on the date of December 9th of this year at the location of 85 North and the exit Sylvan Road, which is located in Hateville, this defendant was involved in a vehicle collision. Upon arrival, officers did observe front end disabling damage to a vehicle. The vehicle had no driver at the time that they arrived on scene to the collision. And so they did contact the registered owner of the vehicle. They did make contact with that individual who is the brother of this defendant. The brother did tell the officers that he had given his brother, the defendant in this case, DeMarlos King, permission to drive his vehicle. At that time, the officers were able to make contact with this defendant, Mr. DeMarlos King, and he told the officers initially that said vehicle that was involved in the collision had actually gone missing. He also denied driving the vehicle to the collision location and basically denied any knowledge of a collision. At that time, the officers, let him know that his story didn't really make sense. And so he asked to speak to one officer privately, and he did admit to being the driver of this vehicle that was disabled due to front end damage. Additionally, Your Honor, they did complete a search incident to his arrest. They took him into custody for hit and run, as well as for obstruction, for essentially telling the officers that he had no involvement in this crime, when in actuality he did. He later changed his story and admitted that he did. And when they did search his person, they did find 20 identification cards with different names on them, and none of them belonged to this defendant. They also found 2 credit cards that did not belong to this defendant on his person. He couldn't really give an explanation for why he had all of these documents on his person that did not belong to him. And so, as pretrial mentioned, he's already got 2 open cases for identity theft and financial transaction card theft in both DeKalb and Fulton. So this would make number 3, where he's possessing basically fictitious documents that are not his, And we also have that he is now in a vehicle collision and not taking responsibility for initially and leaving the scene of the collision. The officers actually had to call his brother, and then that's how they were able to find out that this is the person who was driving and left the scene of the accident. So for those reasons, the state does believe he's a risk of reoffending, as well as a flight risk based on those two very recent FTAs that the state did previously note. So the bond recommendation is a $3,500 surety bond, $2,000 on the hit and run, $1,000 on the driving while $500 on the driving while suspended, $500 on the obstruction, and $500 on the possession of false documents. The state is also recommending no driving whatsoever while on bond because he was suspended at the time of this incident, and he is currently still suspended. His license is still, not a good license to drive on. It's suspended, and nothing further from the state at this time.
All right, give me that recommended breakdown again.
Yes, Your Honor. The breakdown is $2,000 on the hit and run, failure to remain at the scene of an accident, $500 on the driving while suspended, $500 on the obstruction, and $500 on the possession of a falsified document. And I would also like to add that we are waiving additional investigation to make a determination as to whether or not we're going to transfer this to the DA's office. Nothing further at this time.
All right. PD Wright?
Yes, Your Honor.
Okay.
So I think it's important that we take it a little slow with this case. There's a few things missing from the picture here. I'd start by saying that the reason why Mr. King's license is suspended is because his license had been suspended prior due to a failure to pay for a traffic ticket. He later paid for that traffic ticket, but his understanding was that he did not need to go to court again once he paid for that ticket, but apparently he did. That's where the FTA comes from, and that's also where the resuspension of that license comes from. From a ticket that he paid for, he didn't think he had to go to court. Turns out he did. There's no knowledge on his part of that. He thought he had taken care of business. As far as the hit and run, he was actually a victim to somebody hitting him. The car that the officers found was the car that he was driving, that he had borrowed from his brother. The car was not, he was not able to drive it, so he went to find his brother, the owner of the car. That's why he wasn't at the scene. It's not like he hit somebody else and booked it and ran away from the scene with somebody injured or another car injured, nothing like that. This was a one car situation. I will move on to the willful obstruction, Your Honor. I think, and the state might need to correct me here, but I think that they are alleging that my client's unwillingness to incriminate himself is what is causing, or is what they are alleging is an obstruction of law enforcement officers. If he believes he is under arrest, or if he doesn't want to give officers any kind of information that might incriminate himself, he doesn't have to. He has a right to not incriminate himself. So I don't think that there is I don't think that charge will hold in the future. As to the unlawful possession of identification documents, it's very clear in their police reports that the state was patting him down for weapons and contraband. That is for weapons and for contraband, not for seeing what's in his pockets. They could have taken a warrant out to search for his belongings if that's what they wanted to do. That is not what a pat down is meant to do. I imagine that the DA's office is not picking up this case because that search just won't hold in court, Your Honor. None of these offenses are violent. There are no victims involved in this case. None of the warrants have anybody's names on it other than my client. As far as the other fraud cases that are open, there are no convictions on those cases. They are in fact open. And the failure to appears are due to traffic tickets. Again, this is not a violent person. This is not a person who is a threat to anybody in the community. If Your Honor sees fit that he not drive, that is certainly something that Mr. King would abide by, but we are asking for a signature bond. Not only because this is a nonviolent cluster of events, but also because it's a very poor investigation of a cluster of events. Thank you.
All right.
And just briefly in rebuttal, Your Honor, as Your Honor knows, this incident just occurred 3 to 4 days ago. So obviously enough time has not passed for a full investigation to be completed, which is why the state did proffer to the court that we are still investigating, and based upon the findings of said investigation, this may be transferred to the DA's office. The state made no statement about the DA's office not taking the case. So I said that we're still investigating to make that determination. Additionally, Your Honor, the state also previously proffered to the court that this defendant told the officer initially that the car involved in the collision that he was driving, that the officer later found out that the defendant was driving, had gone missing. Now, Your Honor, that's a lie. So that's not the same thing as not wanting to incriminate yourself. That is perjury. That is telling an officer a lie. So, you know,
that's not perjury. That's
okay, it may not be under oath, but it's still telling a law enforcement official a lie. So that's not the same thing as not wanting to incriminate yourself. Additionally, Your Honor, everybody who is taken into custody, there's going to be an inventory search done of that person. And so the officers would have inevitably found these fictitious documents that were on this defendant's person. And so I find it interesting that defense counsel said something about the defendant not wanting to incriminate himself. That's contradictory to her prior statement about him being a victim in this case, where she claimed that he was hit by another, that he was the victim and somebody else hit him. So if you're a victim, it would seem that you would want to cooperate with the police and tell the police what happened and that you were a victim and that you were hit. It doesn't seem like a victim would tell the police that the car went missing and that when the car initially, when he did make contact with the police, tell the officers that he was not the driver and that he was not involved in the collision. That is contradictory to him being a victim in this matter.
Your Honor, it is not difficult to understand why a person would not want to cooperate with the police in any regards, especially someone who's had contact with police, someone who might be nervous around police and not comfortable fully discussing anything outside of the presence of their attorney. There are so many things that the state said that I would want to go point by point, but I don't think that's necessary. This is, after all, a bond hearing. And my final thoughts are the same. This is even a cursory reading of this police report would allow somebody to see that the police officers did a poor investigation. These are not violent crimes. And I would also like to say, Your Honor, that just because someone is arrested doesn't mean that officers don't need a search warrant to open a wallet or see what is inside someone's private property. Inventory at the jail is completely different than an officer investigating the person when they are just patting down for weapons. There's very good, very old case law for that. Thank you, Your Honor.
All right, thank you. Okay, I will order a signature bond in the amount of $3,500. And let's see on my math, that's 2,000 on the hit and run. 500 on the suspended, no, wait, the suspended license was off, correct? The willful obstruction. And then another 500 on the unlawful display. That doesn't add up my math.
That's 3,000 so far.
And then is there one more charge?
Mm-hmm.
Oh,
Driving while license suspended.
right. And 500 on that one. So that will be, is that, yeah, so that'll be 3,500, correct?
That's 3,500, yes.
Got it. So 3,500 SOD jail. No drugs, alcohol, or weapons while on bond. And was there any other request from the?
I asked for no driving because his license is suspended. Whether he had
All right.
knowledge of it or not, it's irrelevant.
Yeah, I will add that to the bond order, no driving.
Thank you, Your Honor.
All right, thank you.
All right, next we have number 20, Ms. Reyes.
Okay.
Email, they think, I got it, thank you, okay.
This is 22 CR 0082227A. And that's Carolina Reyes, charged at 1 count of battery, family violence. 2nd count cruelty to children in 3rd degree. 3rd count cruelty to children in 3rd degree. All with the offense date of December the 11th, 2022. Retrial.
She has one cycle from 2012 for theft by shoplifting, but this position was not on docket and nothing further.
All right. ASG Select.
Yes, Your Honor. On December 11th, 2022, at approximately 8:49 a.m., Officer West was dispatched to 1817 Hemingway Lane, that's Roswell Village Apartments, where officers were already out on the scene. Officers had spoke with the defendant, Ms. Reyes, and she stated that she received a call from her brother, who stated that their mother and her boyfriend's mother, who is the victim in this case, Ms. Rodriguez, got into a verbal argument, causing the brother to take the defendant's mom home. The defendant arrived at the incident location upset and looking for Ms. Rodriguez, who is her boyfriend's mother. Ms. Reyes's boyfriend, Mr. Omar Rios, was present along with their 2 children, 8-year-old initials SRR and 2-year-old CRR. When the defendant walked into the apartment, she began banging on the bathroom door where Ms. Rodriguez was taking a shower. When Ms. Rodriguez came out of the bathroom, the defendant stated that Ms. Rodriguez accused the defendant of cheating on her son. The two engaged in a verbal altercation, and Mr. Omar Rios stated that he witnessed the defendant attack Ms. Rodriguez, his mother, creating bruising near her right eye, deep scratches on her back. Omar Rios also stated that he had to pull the defendant by her hair to get her off of his mother, Ms. Rodriguez. Mr. Omar Rios stated that the defendant escalated the situation and started the physical altercation. When officers asked if the defendant had any injuries, she looked at her and stated no, that she did not have any injuries. Ms. Rodriguez, Mr. Omar Rios, and the 2 children and the defendant all live together and have lived together for the past several years. Due to the nature of the incident, this being a family violence incident, them all living together and had been living together for several years. This incident also occurred just on yesterday. This incident escalated very quickly and became violent very quickly in front of two children, two minor children, 8 years old and 2 years old. So as stated, due to the nature of the offense and what we know about the cycle of violence, the state would be asking for a $6,000 surety bond total, $4,000 on the battery family violence, $1,000 per cruelty charge, no contact with the victims and witnesses. That would be Miss Margarita Rodriguez. Margarita is spelled Margarita, and Rodriguez is spelled Rodriguez. The witness in this case, Mr. Oscar Omar Rios, and Omar Rios is spelled Omar-Rios. The state would also ask for third party transfer for the shared children that she and the witness, Mr. Omar Rios, share, and 1 day anger awareness if Your Honor is inclined to impose that as well. Nothing further at this time. We would also ask for a stay away from the incident location as well.
All right, PD Kim.
Yes, Your Honor, Ms. Reyes she has been here in Georgia for 26 years. She's only 28 years old, and her child, I believe, her children are 1 year and 8 years old, according to my client. And Your Honor, she does not have any employment for the last 2 years. She has been a stay-at-home mother to take care of 2 children of Margarita Rodriguez's son, who should be responsible for those 2 children and being a good co-parent. Anyway, she is qualified for public defender's service, so our office will be continuously representing her. And her education was up to 11th grade, and then she completed GED. We would like to request we have no objection to stay away from that incident location, since that is the children's father's house, which is divorced from the mother, the complaining witness. So, however, my client does not want to stay there. She wants to move out and stay with her own mother and brother because of the conflict and tension in the household. My client was defending herself, and she feels very unfairly treated by this situation. We would like to request for a signature on bond, since this is her first incident that is involved in any kind of violence whatsoever. And also, that's all it is. And we would like to request for a signature on bond for this case. Thank you.
Okay. The state would argue that, just according to the report, what started all of this was a verbal altercation that the defendant's mother and the victim in this case, they got into an altercation. The defendant was informed that her mother was taken from the location, taken away. And so that incident could have been resolved at that point, but the defendant took it upon herself to go to the location and start another altercation, and it eventually turned violent. So I just want I would like the court to consider that as well. Thank you.
Your Honor, I would like to mention that she resided there. She has resided there. That is her place, her children, 2 children, and their father's place. Your Honor, the mother is actually not supposed to be there because she's divorced from her father's father. She has another boyfriend, indeed. I don't understand why she's still there. So, but anyway, yeah, we don't want to get into that detail.
Okay. I'm going to give the $6,000 signature bond through the jail. which will be 4,000 on the battery and 1,000 on each of the cruelty charges. I'm going to order no further contact with the victim, Margarita Rodriguez. I say victims and the two children. What was it, SR and CR? I may have those initials incorrect.
It's SRR and CRR.
Okay.
Your Honor, they are my client's children, and the father, since he is not actually married, and he has not actually gone through any kind of legitimation and has not been paying for any child support, he has no custody over those children. So those children have to be with either my client or my client's mother.
And Your Honor, the state did initially recommend a third-party transfer.
Thank you, Your Honor. That would be awesome.
Minor children.
And so we will ask for that third-party transfer for any visitation with the children.
Yes, Your Honor.
And so with the victim, we still need to have no further contact, right?
Yes, Your Honor, that is totally fine.
And then we don't need the stay away.
The state would recommend the stay away, Your Honor. The victim lives at that location, and I would argue that the victim or the defendant in this case does have somewhere else to go, seeing as though her brother escorted her mother from that home, like took her to another house. So I would ask if the court could ask the defense if the defendant has somewhere else to go, but at this time, the state would be recommending a stay away from that incident location as well, because the victim does reside there.
We have no objection, Your Honor.
No objection?
No
Okay.
objection.
Okay. So then the stay away from 1817 Hemingway Lane?
Yes.
Yes, Your Honor.
Okay. No drugs, alcohol, or weapons while on bond. And I think that will be it. Is that correct?
Yes, Your Honor.
Okay.
Thank you.
Your Honor, would you be inclined to order a one-day anger awareness?
No, not since it's through the jail. I won't do it.
All right, understood, Your Honor.
Mm-hmm.
And that concludes my business. May I be excused?
Yes, you may. Have a good one.
Thank you. You too.
Position 21, Smiley.
This is 22 CR 008228D Melvin Smiley. You're charged with 1 count of criminal trespass, and the offense date is December 10th, 2022. Pre-trial.
68 cycles, sorry. Last arrest November 13th of this year. With Marta for criminal trespass. He appears to have an open case out of DeKalb County for public drunkenness, disorderly conduct, and criminal trespass. He has a willful obstruction of a law enforcement officer conviction from 2022, criminal trespass conviction from this year, a criminal trespass conviction from 2018, criminal trespass conviction from 2016, a battery family violence conviction from 2014, a disorderly conduct conviction from 2012, a battery conviction from 2009, a willful obstruction conviction from 2009, and he also has some conviction in the 90s, if you would like those as well. Judge.
Okay, go ahead.
Aggravated assault in 1990, theft by shoplifting 1991, criminal trespass 93, disorderly conduct and criminal trespass 2005, affray 2005, disorderly conduct 2005, disorderly conduct 2007, forgery in the first degree 2006. And he has at least 5 FTAs and 5 probation violations. Battery 2002. Willful obstruction 2001. Simple battery carrying a concealed weapon 2001. And he has 3 arrests out of South Carolina. The last was October of 2021 for public disorderly conduct. That may be an open case, no disposition listed. 2017 South Carolina public drunk, that was a conviction. And then 1990 assault and battery out of South Carolina, no disposition. And that's further.
Okay. All right, Deputy Falk.
Yes, Your Honor. This happened December 10th, 2022 at 7:14 a.m. while patrolling College Park train station at 515 Ralph David Abernathy. The defendant was observed entering the West Fair Gate and walking to the platform. The officer approached him, asked him to place his hands behind his back. He did have a MARTA suspension from January 1st, 2022, where he was not to resume riding until February 12th, 2023. He also had a pending suspension from November 13th of 2022, where he was not to resume riding until May 25th, 2023. And it looks like he went through that West Fair Gate without paying, which is why he was placed under arrest. The defendant, as you know, has 65 cycles. He's 62 years of age. His most recent were this November 2022 criminal trespass from MARTA, where he was asked to stay away from all MARTA stations and abide by MARTA suspensions by Judge Morrow. And the August 2022 criminal trespass obstruction, where he received time served. And that was also at MARTA. The state's recommendation is $1,000 surety bond, no alcohol, drugs, and weapons, stay away from all MARTA locations, which is already part of his existing probation. That is all.
Okay.
Yes,
PD Kim?
yes, Your Honor. Mr. Smiley he has been here in Georgia for 60 years out of 62 years. And he has 3 adult children, but he's not married. He does not have any parents or siblings who can bail him out at this point. He has not had any employment for the last 6 months because of his arthritis. He's barely walking without wheelchair. He may need wheelchair very, very soon. He was working as a landscaping worker to cut grasses, getting $300 a week. And now he's not making any income. So he's qualified for a public defender's service, and our office will be continuously representing him. And she just lost one sister who was able to help him, and she's no longer here in the earth, and he applied for disability. However, he has not gotten any approval yet. So he's in a very difficult situation financially. We would like to request for a signature on bond. And that's it, Your Honor. Thank you.
Okay. I will order a $1,000 signature bond through the jail. No drugs, alcohol, or weapons while on bond. And please stay away from all MARTA. And have to take share riding, cars from other people, Uber, but you cannot ride MARTA. You've been under several suspensions and violated them with MARTA, and they all just get you brought right back to the Fulton County Jail. So you're going to have to find other means of transportation until your bond ends. All right.
Thank you.
All right. No drugs, alcohol, or weapons while on bond.
Position 24, Young.
This is 22 CR 008230E. Austin Young, charged with 1 count of simple battery. Offense date December 10th, 2022. Pre-trial.
Yes, 7 cycles. Last arrest was November 24th, 2016, out of Indiana for public intoxication and criminal trespass. That case does not have a disposition listed. He had a 2012 conviction out of Indiana for resisting law enforcement. And nothing further. All of the 7 cycles are out of Indiana, but the one I just stated is the only one that's showing a conviction on my GCSE.
Okay. All right. Deputy Falk.
Yes, Your Honor. This incident happened December 10th, 2022. Officer Carlisle responded to 6970 Kimberly Mill Road around 12 p.m. Officer Carlisle made contact with James Bolden. Miss Bolden informed officers she had been attacked by one of the other tenants inside the residence. Ms. Bolden stated that the defendant hit her several times and then kicked her while she was on the ground after the two had a verbal dispute. Bolden provided officers with the video of herself and the defendant arguing before she was physically assaulted by the defendant. On the video, you can see Ms. Bolden talking into the camera before the phone is dropped after being assaulted. The state's recommendation in this case is a $4,000 surety bond. That's due in part to the defendant's history outside of the state, as well as this incident itself. The further recommendations are stay away from the incident location of 6970 Kimberly Mill Road in College Park. No alcohol, drugs, or weapons, and 1 day anger awareness. Thank you, Your Honor.
All right.
Yes, Your Honor, Mr. Young he was born 1974. He is 48 years old, and he does not have an employment at this point. Indeed, he was working at furniture store temporarily. However, he is currently it was temporary job. He does not have a permanent job. He does not make any income at this point. He is residentially challenged at this point, so we are recommending social worker services for his housing resources. He will be qualified for public defender's service, so our office will continuously defend him. And he has been here in Georgia for about 5 years. He has a sister and niece and nephew. However, he's a single, and he believes that this is false allegation where he feels like he was a victim of hate crime and slander. And we would like to request for a signature on bond. I believe that all those charges from Indiana are quite a bit remote. They are from 2016 without any disposition. So we would like to request for a signature on bond. Thank you.
All right.
And Your Honor, I find it ironic that that the defense is saying that this is a hate crime against Mr. Young, given that our victim is a trans woman.
All right, I'm going to order $4,000 surety bond. I'm going to order stay away from 6970 Kimberly Mill Road. I'm going to order no further contact with the victim, Jane Bolden. I'm going to order no drugs, alcohol, or weapons while on bond. And that'll be it for now.
And just to make sure we have it correct for the record, Your Honor, it's James, James.
Oh, I'm sorry.
Bolden.
I didn't hear you. I apologize.
Not a problem, Your Honor. And let me just make sure. Bolden is the spelling of the last name.
Okay. Thank you. Sometimes the speakers are not good on here. And then, of course, we're ordering that the social worker work with him to see if there's a possibility of helping with
surgery once for my jaw and everything. I got a lot of oral surgery going on right now.
Mr. Young, I would like to strongly recommend you to stay silent. You have your constitutional right to remain silent.
You done. You done. Position 12, Jones.
This is case number 22 CR 0082226B. Tyler Lorenzo Jones, you charged with 1 count of battery. The offense date is 12/9/2022. Pretrial.
Yes, 3 cycles. Last arrest was March of 2016 for aggravated assault and a contempt violation order in Nashville, Tennessee. There's no disposition listed on that 2016 case. And then all of his arrests were assault from Tennessee. The first cycle was dismissed. The second and third cycle both have no disposition, and they're both from 2016. And nothing further.
All right.
Your Honor. Yes, Your Honor. This happened December 9th, 2022 at 10:42 p.m. at 925 Canterbury Road, Northeast, apartment 210 in Atlanta, Georgia. Officers were dispatched to the location in reference to a dispute between 2 males. They spoke with Brennis Graft, that is BRENNIS GRAFFED, who advised he was assaulted by the defendant, his ex-boyfriend. He stated they got into a heated argument on the way back from his job's holiday party. And upon arriving at the apartment, the argument became physical and the defendant physically assaulted Graft, punching him in the face. Graft's left eye was bleeding, which was observed by the officer. He also had a laceration under his left eye. The defendant was contacted by police and did admit to fighting Graft and punching him in the face. As Your Honor has already heard, he had a 2008 assault bodily injury out of Tennessee that was dismissed, but more importantly, he had an assault domestic bodily injury in Tennessee in 2016 involving the same victim. We did have an opportunity to speak with the victim, who stated that he and the defendant are not in a relationship. They do not live together, that the defendant came here from Nashville to go to the job's Christmas party with him, and that his eye was bleeding as a result of the incident. He stated he did seek medical attention. The victim was told, Mr. Graft stated that the doctor told him it will heal on his own. He further stated this is not the first time this has happened. The defendant was arrested 5 years ago in Nashville for violence against him. And he stated the defendant's car is still at his home and he will need to have a law enforcement officer or be accompanied by a law enforcement officer to retrieve that. The state's recommendation, due to the fact that this is the second incidence of violence with this same individual, as well as the fact that the defendant has 2 previous instances of violence in addition, that 2008 dismissed assault bodily injury in Tennessee and that criminal contempt and aggravated assault in 2016 in Tennessee. The state's recommendation is a $7,500 surety bond, stay away from 925 Canterbury Road Northeast, apartment 210, no further contact with Mr. Brennis Graft, that is BRENNIS GRAFFED, no alcohol, drugs, or weapons, 1 day anger awareness. Would also like to point out this defendant has no ties to this community. He lives and has committed his crimes in Tennessee up until now. That is all.
All right. PD Wright.
Yes, Your Honor. Mr. Jones was invited by the complaining witness to come to this holiday party. He came down from Nashville, where he lives, to attend this party, and we would heavily dispute that it was Mr. Jones being the aggressor. This was 2 men that got into a verbal argument, and he wasn't, the complaining witness was not the only one with injuries. However, the police never spoke to Mr. Jones about whatever injuries he may have. He has a huge knot in the back of his head. He states that he was defending himself from the complaining witness, who was the aggressor. He came here to spend a nice time with an old friend, and instead he got wounds on his head and then arrested. He's 33 years old. He's a postal worker. He's been a postal worker for 10 years. And I know that the state sometimes makes the argument that because a defendant doesn't live in Atlanta or they live in a different state, that somehow makes them a risk to skip on their court or anything like that. It doesn't. Mr. Jones let me know that a few years ago he did plead guilty to his case, and the other case was dismissed. He did his time, he did what he needed to do, and he had thought he had moved on from that. This is much later. This is 2022. I think that sufficient time has passed that it shouldn't hold against him. Your Honor, I think that the $7,500 bond is too high. I think that Mr. Jones should have a signature bond on his case.
Okay, I would like to also speak into that.
Hold on a second. All right, you are the victim in this case.
Yes.
And you wish to address
Say that again.
And you wish to address.
Yes, I will.
All right, I need to swear you. Raise your right hand. Do you affirm that the testimony that you give is the truth and nothing but the truth and nothing but perjury?
Yes.
All right, are you on?
Am I on what?
Two different devices.
I'm outside. I'm sorry. I had to step outside. Give me one second.
Oh, okay. And it
Okay, can you hear me now?
That's a little bit better. All right, what would you like to tell the court?
So, well, the first thing is I'm not sure where the story came that I was an aggressor. For one, I'm not a person that if you see my record in Tennessee as well as my record in Georgia, which I don't have a record, I'm not a person that is a person of aggression. I'm a person who likes to find reasoning in things, whereas I try to find a resolution in things. And in this situation, and granted, I don't think that Tyler is a bad person. I think that sometimes when he gets a little intoxicated, he becomes angry, which causes him to become violent. In this situation, granted, yes, he was invited to my holiday party because the thing was that we were going to rekindle, of course, our relationship, being that it had been years. It had been about 2 years or so because I moved from Nashville about 2 years ago, almost 2 years ago. And in this situation, I asked him if he wanted to come, and he said that he did. And so I was okay with that. What had happened was there was some conversation obviously had that I wasn't involved in at the party about someone not purchasing drinks or a shot for him. When I had made sure that we had enough money that if we needed to purchase more drinks other than what was provided to us, that we had that money. So I didn't know that something was said until when I saw his whole mood change. He decided, that he was going to be separate from everything else. And I'm like, well, what's going on? And to keep me from being embarrassed or anything like that at my work function, I said, well, let's go home. And of course, he didn't want to go home. And so I was like, well, I want to go home because I'm in a high position in my job. I'm not going to be embarrassed or anything like that. So I offered them to bring the car so that we can go home. It was when I asked, because he also had my door key, because of course, him living in Nashville, he had to come to my house, and I had to still work. And I told him I would give him the key, which I did. So when we got back to the house, I said, well, can you give me my key? Of course, he cursed me out. And then when I got in the house is when the situation happened. I didn't even have time to defend myself because as soon as I closed the door in my home, I have this, it's a divide. My home is kind of divided inside. So as soon as I closed the door, I was attacked. So I don't know where the story came that he was defending himself. There was no point he'd ever have to defend himself because when I grabbed my wallet, I grabbed my phone to call the police. My phone was snatched out of my hand. So overall, I managed to grab my phone, I managed to grab my wallet, and I managed to grab my keys, and I ran outside. It was when I got to the next building is when I called the police. And so then I was being chased outside to where I had to run into the workout area where I live so that I knew he didn't have access because I had the key fob. And that's where I waited until police came. So like I said, he's not a bad person. It's just when he gets intoxicated, these things happen. But I honestly don't know where this story come from that him having to defend himself or I'm an aggressor. So because that's an attack on my character. That's not who I am. Never been who I am. My mom raised me with respect, with dignity, with character, and I stand by those things.
All right. Are you in fear of Mr. Jones?
No, I'm not in fear of him.
Okay. Okay. All right. Well, I appreciate your testimony. Anyone have any cross-examination for the victim?
Nothing for Dr. Graft, Your Honor.
Yes. All right. ASG Wright, is this your case?
Yes, I'm the PD though.
I'm sorry, PD.
No worries, Your Honor.
It's been a long day. Sorry for that. Okay.
Absolutely. Yes. I ask that the court allow Mr. Jones to pick up his belongings. I have instructed him that he could do so with a sheriff if he makes an appointment to do that.
Okay.
And we'd ask for no further violent contact, Your Honor.
Okay. All right. Anything else before I rule?
No, Your Honor.
No, Your Honor.
All right, I'm going to order a $5,500 surety bond. I'm going to order a stay away from the 925 Canterbury Road Northeast. I'm going to order no further contact with the victim, Dr. Brennis Graff. I'm going to order no drugs, alcohol, or weapons while on bond. And that's all I'm going to order at this time.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Thank you.
Position 11, Johnson.
This is 22 CR 0082225A. Lindarius Johnson, charge of 1 count of battery, offense date 12/10/2022, pretrial.
Yes, 6 cycles.
Pardon me.
Okay.
Last arrest was May 25th of this year for theft by receiving stolen property. That is an open case, 22 CP 204342. He has a second open case for terroristic threats, 22 CP 208685. A third open case for fleeing or attempting to elude and theft by receiving stolen property, 21 CP 204498. 1 FTA from this year and nothing further to add.
All right. PD Falk.
Yes, sure.
ASG Falk.
Not a problem.
All right, now it's even. Okay. Sorry about that.
No worries. This happened on December 10th, 2022 at 3:30 p.m. at 1380 Atlantic Drive in Atlanta. The defendant struck Kiwana, and that's Keywana Jones, common spelling, his girlfriend, in the face, resulting in a swollen jaw, abrasions to her lower and upper lip, and scratches on her neck, as well as a possible injury to her right eye. As you have heard, this defendant has 3 open cases. On the case in 2021, the theft by receiving, he received a $3,000 surety bond. On the January 2021 case, the fleeing and eluding and theft by receiving, he received a $5,000 surety bond. And on the January 21st, 2022 terroristic threats case that involved the mother of his child, he received a $15,000 surety bond. We did have a chance to speak with Ms. Jones. She stated that she and the defendant are no longer in a relationship. They never lived together and they share no children. She stated this is not the first time that this has happened, but this is the first time police have been involved. She further stated that she does not want any contact with the defendant and she wants him to stay away from her home at 584 Greyhawk Way, Fairburn, Georgia. Based on the fact that the defendant has 3 open cases, and I understand that the PD's office is going to say that he is presumed innocent, but he has 3 open cases, which goes to the Ayala factor of a risk of reoffense. Additionally, he has an FTA from this year, which goes to the Ayala factor of whether he will show up for court or not. So based on all of these factors and the fact that he has a previous terroristic threats involving another individual who he had a relationship with, the mother of his child, and the fact that the victim in this case stated this is not the first time an incident of this nature has happened, we are requesting a $7,500 surety bond, stay away from the 584 Greyhawk Way, Fairburn, Georgia address, no further contact with Kiwana Jones, 1 day anger awareness, no alcohol, drugs, or weapons. That is all.
All right. PD Wright.
Yes, Your Honor. Mr. Jones is 18 years old. He's lived his entire life in Georgia. He lives in Union City, and there is no way that Mr. Johnson could make a high bond of any amount, $7,500 being much too high for this battery charge. He has no problem staying away and no longer contacting the complaining witness. As far as his open cases, Your Honor, I would just say that the state can stack a million cases and call them open on any defendant, and it's still not a single conviction. He has not been convicted of any crime, and that needs to be said, and it needs to hold water. I think that $1,000 bond for Mr. Johnson would be fair, and that might be something that he and his family could make. That would be all for me, Your Honor.
I'm sorry, I didn't realize this. PD Wright, you said he's 18?
Mr. Johnson?
Yes.
Yeah, he's 18.
Okay.
Did you not know that?
I was not aware that somebody that young had racked up this many cases so far. So no, I was not aware, but thank you for letting me know that. Your Honor, nothing.
You're welcome.
Mistake.
All right. I'm going to order a $6,500 surety bond. I'm going to order a stay away from 584 Greyhawk Way, Fairburn, Georgia. I'm going to order no drugs, alcohol, or weapons while on bond. And no further contact with Kiwana Jones. And I think a one-time escort back to the property to get any personal belongings that he may have.
Thank you, Your Honor.
Thank you.
Position 10, Hines.
All right, this is 22 CR 008244Y. Marcus Hines, charged with 1 count of simple battery family violence. The offense date is December the 10th, 2022. Pre-trial.
6 cycles, last arrest May 9th, 2013 for a probation violation out of Fulton County. The underlying charge was a 2011 possession of a firearm by a convicted felon. And then he also has a 2005 conviction for aggravated assault, armed robbery, into an auto. And another probation violation from 2003. The underlying charge is the aggravated assault on an officer from 2002. And nothing further.
Okay.
Good afternoon again, Judge.
Yes.
This incident is alleged to have occurred on December 11th, 2022 at the location of 3440 Boulder Park Drive, Southwest Atlanta. On that particular date, Officer Rogers was called to the above location and he met with Miss I'm not sure if it's still pronounced Nicole, but it's Niqcole Davis. He had a conversation with her, and she indicated that Mr. Hines returned to the home where they both were residing. He was intoxicated, pushed her down, and snatched her car keys out of her hand. The officer did note that he did observe a minor carpet burn on Miss Davis's right elbow. We're asking that the court consider that since they were, I'm not sure if they're currently in a relationship, but they were in a relationship at the time, boyfriend, girlfriend, and reside together. We're asking the court to consider that there is a risk of him intimidating Mrs. Davis. Also, we would ask the court, I did not hear, so I'm not sure if pretrial has a notation of it or not, but I noted in his GCIC that appears at some point he was a fugitive from justice out of Washington, D.C. So we asked the court to consider that additionally in reference to him appearing to court when his court date comes back or his ties to the community. Additionally, we asked the court to consider that this was something that had occurred according to the police report where Mr. Hines had returned to the home, had spoken to the children. The children indicated something to him that he wasn't happy with, and that's what led to Miss Davis being pushed by the defendant and her keys being snatched from her. The officer did give Miss Davis her keys back. He recovered them from the pocket of Mr. Hines. So we're asking the court to set a surety bond for the charge of the simple assault family violence. We're asking for a bond of $5,000 surety bond, no further contact with Miss Davis, and for him to stay away from the location where the incident occurred, and anger awareness, and no alcohol, drugs, or weapon during his time on bond.
Okay. PD Wright?
Yes, Your Honor. As the state, I believe, stated, Mr. Hines was coming back from his father's funeral. He was in an altered state of mind. He was very much in pain and having a really, really difficult time. He understands that he acted out of line, but he's 40 years old. He has a really good job. He works at GCI Ingredients, which is a factory. He does live with the complaining witness, but he's let me know that if the state or if the court so rules, he would be happy to take his stuff and live elsewhere while the case is open. He does have prior convictions, Your Honor, but they're quite old. And I think that that's something that this court needs to consider. He's worked very hard to get his life back. He was going through a very, very difficult moment. And we'd ask that you consider a signature bond for Mr. Hines.
Okay. I'm going to order the $5,000 surety bond. I'm going to order that he stay away from 3440 Boulder Park Drive and have no further.
Excuse me, ma'am. Judge, can I speak for a minute, please?
I bet your attorney's gonna not to.
Mr. Hines.
I don't have no money for no bond. I don't have nobody to help me. And I lose my job, and that's why I was trying to get a signature bond, because I don't have nobody to help me. I just buried my dad. I buried my mom a few months ago. And if I don't work, I can't pay for nothing. I lose my job. So I don't have no money. I don't have no money. I spent all my money on the 10th on my daddy's funeral. I don't have no money. I'm broke until I go to work.
All right.
And I don't have nobody outside. They love me why I ain't call nobody nothing. I don't have nobody to look out for me. As far as money-wise, as far as somebody let me stay there, let me stay until the case is solved. But for the money, I gotta work them out myself.
All right, well, due to the facts of the case, and you do have some history, I will lower it to $4,000. So that is the best I can do now until you come back up for a bond review. So I'll lower the bond to 4,000, sure.
Ma'am, please, because I don't want to lose my job. Please, please, that's the only job I have, and the only, please, please. Now, some of that stuff with about that Washington DC is for when I was already on probation and the Fed picked up the case. That's why I had one out in Washington DC. But I didn't know that until I was already on doing that. But I don't have no money, no people. I just lost my
Mr.
mom.
Hines,
Oh,
Mr. Hines, I understand, and the court also understands the difficult position, but at this time, I'd ask that you not say anything further to the court.
Yes, ma'am.
All right, thank you. All right, and I don't know if I said no drugs, alcohol, or weapons while on bond. $4,000 surety bond.
Position 6, Dawson.
Okay. You said 6?
6, Dawson.
Okay. This is 22 CR 0082248. Travis Dawson, charged with 1 count of DUI under the influence. And another count of DUI less safe, both with the offense date of December the 10th, 2022. Pre-trial?
He has 3 cycles. Last arrest was from November 2011 for trafficking in cocaine, 2 counts out of DeKalb County. He eventually, the conviction was possession of cocaine and possession of a Schedule I controlled substance in 2013 from that case. And then the first arrest was a possession of marijuana less than an ounce conviction. Nothing further.
So how many cycles again? I'm sorry.
3, including today's arrest.
Including today. Okay, thanks. All right, Deputy Falk.
Yes, Your Honor. This happened on December 10th, 2022 at 1400 Old Alabama Road in Roswell at approximately 2 a.m. Officers were dispatched to a stalled vehicle which was hanging over the curb at Old Alabama Road. They made contact with the defendant who was standing near the vehicle, and he made spontaneous utterances that he was the driver, as well as the fact that he had had 4 tequila shots from between 3 and 4 hours prior. He had glassy, watery eyes, odor of alcoholic beverage coming from his person. He also had dirt on his pants, and when asked by the officers what happened, he stated he was trying to push the vehicle off of the curb. He had further stated he was leaving a Christmas party, became confused by the GPS, entered the parking lot and tried to exit, and he missed the turn and ended up on the curb. He failed field sobriety. So at that point, he was read and applied consent, took the Intoxilizer 9000, and his readings came back 0.174, which is over twice the legal limit. As you have heard, this defendant does have an issue with substance abuse from that 2011. He had a possession of marijuana less than an ounce in 2011 and possession of cocaine and possession of Schedule I in 2013. And now this case, we are asking for a $6,000 split bond. That's $3,000 on the per se and $3,000 surety on the per se, $3,000 signature on the less safe, no alcohol, drugs, or weapons, no driving without a valid license from DDS, and we're also asking for ADET. Thank you.
All right, PD Holly.
Yes, Judge. Mr. Dawson is 31 years old. His last arrest is over 10 years ago. So while I understand that there is concerns about substance abuse, he hasn't been in trouble in the last 10 years, and he's had no additional troubles with controlled substances at all since that instance. He's lived in Atlanta for his whole life, and he currently works construction as a field engineer. So he has a good job. He's been working that job for nearly 7 months. He lives in Lithonia, and he does help care for his elderly grandmother. We would ask the court consider a signature bond for this. He is recommended for pretrial. as far as I know. And I believe that the state has presented quite a bit of evidence, but at the end of the day, one of his prior cycles is something the state doesn't even prosecute at this point, and the other one is over 10 years old.
Okay. I will do the split bond. 3,000 surety bond on the per se, and 3,000 signature bond on the less say. I will order no drugs, alcohol, or weapons while on bond, and no driving unless you have a valid license from DDS.
So Judge, repeat that again. On the first charge, it's a 3,000 good bond?
Yes.
And on the second one, is through who?
3,000 SOB jail.
Thank you. So a total $6,000 bond.
Yes, 6,000 split.
Thank you.
Thank you.
Thank you, Your Honor.
Mhm.
Position 7, Gates.
This is 22 CR 008237F. Roy Gates Jr., charge of 1 count of battery and a 2nd count of cruelty to children, 3rd degree, December the 10th, 2022. Pre-trial.
15 cycles. Last arrest was November 9th of this year in Carroll County for a probation violation. He appears to be on probation in Carroll County for murder and voluntary manslaughter. Disposition was March of 2013, 10 years confinement, 10 years probation. Has a battery and simple battery conviction from 2003, a theft by receiving stolen property conviction from 2007, a given false name conviction from 2006, a FTA from 2006 and 2009, probation violation 2005, 2007, 2008, 2012, and then the 2022, and nothing further.
All right.
Judge, the alleged facts of this case occurred on December 10th, 2020 at the location of 630 10th Northwest, excuse me, Judge, 1 second, apologize. Yes, Judge, Northwest Atlanta, I believe it's 10th Street at about around 7 o'clock. Officers arrived and responded to the location. They met with one of the victims, Miss Angela Johnson, who was holding her 4-year-old daughter, RJ, initials RJ. Miss Johnson stated that Mr. Gates hit her in the face while she was holding her daughter in her lap. The officer did observe swelling to Mrs. Johnson's upper lip. The officer did speak with Mr. Gates, and he stated that he didn't have any altercation with Miss Johnson. What occurred was that they were at a bus, Miss Johnson was at a bus stop, and eventually Mr. Gates came, sat next to her. They have no previous contact. They do not know each other, and they were kind of making small talk for a couple of minutes. And next thing you know, Mr. Gates hit Miss Johnson in the face. There was video obtained, and it does show the interaction between the defendant and the victim in this case, Judge. We're asking the court to consider that one of the main things, other than his record, which I'll get to in a moment, is that he would be a danger to the community, and that this was a stranger. He did not even know this was a public place. This is a place that the public would frequent, being a bus stop to try to get public transportation. We believe that that is very indicative of the fact that he is a danger to the community. And touching on that, as pre-trial mentioned, he does have many arrest cycles and convictions. There's a conviction for battery, the conviction for the murder or manslaughter, and that was back in 2013. I believe his sentence was 10 years, followed by probation. Since then, of course, he's had probation violations, and he has a FTA, two different FTAs from 2006 and 2009. We're asking the court to consider that he is a threat to reoffend, a threat to the community, and a risk of not returning to court, and that he has the two FTAs, he has the probation violations. Those show that he is not amenable to following the court rules and showing up for his court dates or probation compliance. So we would ask the court to set bond at a $5,000 surety bond, no contact with the victim, stay away from the location, and anger awareness, and no alcohol, drugs, or weapon during the time on bond.
Okay.
Yes, Judge. Mr. Gates is 36 years old. He is currently unhoused, but he does receive Social Security. He is also married. We understand his history. However, the FTAs are extremely old, 2006 and 2009. Those are both almost 15 years old. I would ask the court to consider the length of time since he is last not shown for court. We would ask for a $1,000 good bond so that he can attempt to pay that bond and be released so that he can try to work during this interim period.
Judge, if I may briefly respond. In reference to the defendant's FTAs, he was incarcerated for the 10 years once he received his conviction for the manslaughter charge. So of course, there would be no possibility of him failing to appear when he's in custody in prison. So we'd ask the court to consider that in reference to the argument as to his failure to appear.
Okay. I'm going to order a $5,000 surety bond. I'm going to order stay away from 630 is at 10th Street Northwest. I believe that's the address. No further contact with Angela Johnson.
Judge, I need you to break down that bond as well.
Oh, I'm sorry. So that's due $3,000 on the battery and $2,000 on the cruelty. And then I said no further contact with Angela Johnson. And do we have the child there with the initials as the other victim? I didn't hear.
It's RJ or the child's initial.
RJ. And no further contact with RJ. No drugs, alcohol, or weapons while on bond. And that'll be the ruling for that case.
Thank you, Judge.
Add-on position 2, Kane.
Okay. This is 22 CR 008242Y. Quentin Kane, charged with 1 count of battery, family violence, and a 2nd count of cruelty to children in 3rd degree. Offense date December the 10th, 2022. Pre-trial.
8 cycles. Last arrest was February of 2008 for harassment in New Jersey. All 8 of his cycles are out of New Jersey. The harassment was a conviction in 2008. And then in 2007, he had a conviction for simple assault. In 2006, he had a conviction for contempt domestic violation. In 2003, false reports to law enforcement conviction. And all of those were misdemeanor convictions out of New Jersey and nothing further.
All right. ASG Campbell.
Yes, Your Honor. The facts as alleged for this defendant are that on the date of December 10th of this year, at the location of 9005 Deer Trail, this defendant and his the mother of his child, the victim, Jasmine Payne, which is also his wife. They were in a verbal altercation over turning off a light in their child's bedroom. And the victim reported to the police that this defendant used his forearm to push her into a wall by the neck. He also punched her in her face. When the officers arrived, they did observe a 2-inch scratch on her face, and they observed defensive wounds on the defendant. Their minor child was present in the home at the time of this incident. So that's why he was charged with cruelty to children. And in light of the fact that the defendant does have prior history for domestic violence related convictions, the state's recommendation for bond is going to be a $5,000 total surety bond, $3,000 on the battery, family violence, and $2,000 on the cruelty to children. We were also recommending a stay away from the incident location, which is 9005 Deer Trail, as well as no further contact with Jasmine Payne, who's the victim in this matter. We have had contact with the victim in this matter, and she did state that she doesn't fear the defendant, and that she does corroborate what was in the police report, which is essentially that she was pushed by this defendant. And I would also like to note that she's okay with him returning back home, but the state's request is still going to be for a no further contact.
And what's the child's initials? For the cruelty?
EP.
I don't have the initials. I just have the last name is Payne.
I think the defendant is saying B as in boy.
E is in Ethan, P is in Paul.
Yeah, I couldn't hear. Did anybody else hear it for me? I couldn't hear.
It's, Your Honor, it's EP. E
Okay.
is in Ethan, P
Is
for
in
the last
Payne.
name. Yeah.
Okay. All right, so EP, all right. And go ahead, PD Kim.
Yes, Your Honor. Actually, I think Miss Jasmine is online, so I do not mind sounding her first.
Okay, Jasmine Payne. Do you wish to address the court, Ms. Payne? Jasmine Payne. All right, we'll keep going. Go ahead.
Yes, Your Honor. Mr. Payne is actually, he was born in 1980, so he's about 42 years old. And I believe he's been here in Georgia about 5 years. He has his child and his wife here in Georgia. He also has an employment, gainfully employed as a supply chain manager. He's been working for the same company in a different state for about 10 years. And he is not going to be qualified for public defender's office. Our service will be ending at the end of this bond hearing. I had a chance to speak with Miss Jasmine, his wife. Of course, she's not afraid of Mr. Payne, and she also wants him to come back home. So we would like to request for no further violent contact. All those incident happened very remotely. It was 2008, more than 14 years ago, Your Honor. We don't have to go that far. I believe the maximum we should have considered is about 10 years, and yet it seems like they consider whole life. Anyway, Your Honor, we would like to request for signature on bond. If Your Honor is not inclined to give him a signature on bond because of his past history, we would like to request for a maximum $1,000 good bond. Thank you, Your Honor.
All right.
Can I say something, please?
No, I would strongly recommend you to stay silent unless it is directly related to the bond.
Okay.
All right, I want to go ahead and give my ruling. And that is, I'm going to order a $5,000 surety bond And that breakdown will be 3,000 on the battery, 2,000 on the cruelty. We're going to order stay away from 9005 Deer Trail. And I'm going to order no further contact with the victim, Jasmine Payne, and no further contact with the minor child, E.P. No drugs, alcohol, or weapons while on bond. All right, that will be the ruling of the court.
Thanks, Your Honor.
Judge, quick announcement for position 16, they waived their appearance and we're completed here in courtroom 2, Judge.
Okay, thank you so much.
Thank you.
All right, we will do position 16, 22 CR 008236G, Rashad Moore, charged with 1 count of criminal trespass, offense date 12/10/2022, pretrial.
71 cycles.
It says 7/1.
Yes. Last arrest November.
Quick summary.
What'd you say?
I said, just give me a quick summary.
Okay.
A quick, short summary.
Last arrest 11/18/2021 for possession of cocaine with intent to distribute, possession of marijuana with intent to distribute, failure to obey traffic control, and sorry, the last arrest was from 11/21 for battery and willful obstruction. The possession of cocaine with intent, possession of marijuana with intent, failure to obey traffic control, and false information to a law enforcement officer appears to be open, 14 SC 131283. Second open case, possession of cocaine, possession of marijuana less than an ounce, 14 SC 131282. He has 18 cycles out of North Carolina. All of those convictions from North Carolina are from the early 2000s to the 90s. As far as Georgia goes, he has a total of 4 probation violations accounted in the last 10 years. 2013, possession of marijuana less than an ounce conviction. FTA from 2012, disorderly conduct conviction from 2012. Entering auto conviction 2011.
Okay.
Theft by shoplifting 2011. Entering auto 2011. I said that. Entering auto 2012. Simple battery 2010.
All right, I won't go back any further. That's a good summary for me.
Okay.
All right, thank you. All right, ASG Campbell.
Yes, Your Honor. Just briefly, the facts as alleged are that this defendant was previously banned from the location of 2479 Peachtree Road, which is the White House Apartments complex. On the incident date of December the 10th of this year, he was found on the property. He parked his bike and he slept there. And the state's recommendation for bond is a $2,500 signature bond. Nothing further.
No objection, Your Honor.
Okay. All right, I will order the $2,500 signature bond through the jail.
And I apologize. I also recommend a stay away from the incident location since he's been banned from it.
Right, stay away from 2479 Peachtree Road. That's the White House apartment complex, so from the whole complex, correct?
Yes, Your Honor, thank
you. All right, no drugs, alcohol, or weapons while on bond. Anything else, counsel?
Nothing further from defense.
No, Your Honor.
All right, thank you. Any more cases? Is that the last, I believe?
Hopefully that was.
Seems like you just did not go away, huh?
Oh. Are we ready?
Yes.
Okay. Once again, everybody, the reset date for the SAP calendar is going to be July. It's been that long of a day.
Right.
December the 27th. Okay.
Right.
All right, position number 1 is reset further notice with a $4,000 total SOB through pretrial. And all of the cases that's going through pretrial are going to be per judge, okay?
Not all of them, only the ones I put in the chat to you. It's just 3.
Okay, so let me put it this way. Positions 1 and 2, positions 8 and 9.
Yeah.
Are there any additional?
No.
Okay, so we have that 1 and 2 and 8 and 9. Okay, position number 2, reset further notice with a $3,000 SOB through pretrial. Position 3 is going to the SAP calendar with a $1,000 good bond. Position 4 is reset further notice with a $3,000 total SOB through the jail. Position 5 is reset further notice with a $3,000 SOB through pretrial. Position 6 is going to the SAP calendar with a $6,000 total split bond. Position 7, SAP calendar with a $5,000 total good bond. Position 8, reset further notice, $2,000 SOB through pretrial per judge. Position 9 is reset further notice with a $2,000 SOB through pretrial per judge. Position 10 is going to the SAP calendar with a $4,000 good bond. Position 11 is going to the SAP calendar with a $6,500 good bond. Position 12, SAP calendar with a $5,500 good bond. Position 13, reset further notice with a total $3,500 SOB through the jail. Position 14, reset further notice with a $3,000 SOB through the jail. Position 15 is going to the SAP calendar with the with the $8,000 total good bond. Position 16, reset further notice with the $2,500 SOB through the jail. Position 17 is going to the SAP calendar with the $5,000 total good bond. Position 18, reset further notice with the $2,500 SOB through the jail. Position 19, SAP calendar with the $4,000 good bond. Position 20, reset further notice with a $6,000 total SOB through the jail. Position 21, reset further notice, $1,000 SOB through the jail. Position 22, reset further notice with a total $4,000 SOB through pretrial. Position 23, reset further notice with the $1,000 total SOB through pretrial. Position 24 is going to the SAP calendar with the $4,000 good bond. Position number 1 on the add-on calendar is reset further notice with the $3,000 total SOB through the jail. And position number 2 is going to the SAP calendar with a total $5,000 good bond. Are there any questions, comments, or otherwise?
You did good.
All right, ladies, let's get out of here, okay?
Yes, all right.
Okay, see everybody tomorrow.
All right, take care.
Okay, bye-bye. Judge is coming to you right now.
Yes, ma'am. Thank you.
Okay. All right.